I've been tossed overboard.
I'll have to bill you extra for my time.
Welcome to the show. You look incredible, like a dessert that owns a yacht.
That's exactly the vibe I was going for. You know, sweet but slightly out of your tax bracket.
Mission accomplished. How does one even shop for a suit when your head is...
Blazing the whip, gotta vanquish the needs. My kingdom for some poppy seeds. Yo, yo.
Police or zombie problems? Your tortoise won't stop breakdancing?
Try blue tape.
The miracle of our age. Yeah! Hey, we love that umbrella guy. All right. Thank you.
I'm calling from Los Angeles, and I'm having a little problem. Under the name ThATuMBRELLAgUY, I sent him my phone number at least 20 times in the chat and told him to call me. He ignored me. I'm a man. I filed the report. If you guys could take a look at it and give me a call back, I would love to hear what you guys can do to help us. We really need to kind of stop this guy at least until Monday. I told him to call me. I'm a man.
You know what? I talk to your mayor.
When I was young, it seemed that life was so wonderful. A miracle, oh, it was beautiful. When I was young, it seemed that life was so wonderful. A miracle, oh, it was beautiful. When I was young, it seemed that life was so wonderful. A miracle, oh, it was
She on the timeline, typing like a toxin. Gossip in the coffee, lies in her pocket. He in a cheap suit, briefcase, cheap grin. Thinking bar exam means he gon' always win. They foul then fumble, every case crumble. Judge side eye, watching every word tumble. Perjury perfume, they wear it like cologne. Tryna burn a kingdom from a glass stone home. You get sued, then you lose, then you do it again. Same script, same scam, you just repress sin. You toss mud, spread names, think the truth won't bite. But the record, don't forget you, it's in black and white. You get sued, then you lose, then you do it again. Whole world taking notes every time you pretend. You toss mud, spread names, think the truth won't bend.
The cycle that you love gon' be your end.
He whisper, I'm the Lord, like that's holy armor. But every filing reading like a bad soap opera. She pointing at the mirror saying, look, that's a monster. But the face look back and it sure look conscious. Mirror on the live stream claiming they the wounded. Timeline receipts, every live time stamp zoomed in. You swing at a critic, think he just a guy online. Now your false words sitting in a sworn headline. Lose and you do it again. Same script, same scam, you just repress sin. You toss mud, spread names, think the truth won't bite. But the record, don't forget you, it's in black and white. You get sued and you lose and you do it again. Whole world taking notes every time you pretend. You toss mud, spread names, think the truth won't bend.
The cycle that you love gon' be your end.
How many doctors, how many docs, how many wins end up as costs? How many victims you invent overnight? How many times can you lie on mic? You get sued and you lose and you do it again. Same script, same scam, you just repress sin. You toss mud, spread names, think the truth won't bite. But the record, don't forget you, it's in black and white. You get sued and you lose and you do it again. Whole world taking notes every time you pretend. You toss mud, spread names, think the truth won't bend. Last page of your story say, this is the end.
What's up, folks? How's it going today? Man, I tell you, there were some weird beginning issues. If you noticed, I'm sure you did. I'm sure you noticed a few of the just stops and nothing happens. That's okay. I was like, what in the world is it doing? Oh Lord, what a day. What a day. It's been funny. So today we actually have something really interesting. We have a 70 freaking page document with an 80-page addendum. That's right. We have a monster of a freaking document. Now, the addendum is not actually required reading by any chance, but the altogether, it is a monster of a filing. Now, these are filings that we have expected for a while. This is the appeal with Dan Owen. Now, as far as this, they are interesting documents. It's pretty, I thought it's pretty good filing. You know, it's a monster. I will be, by the way. I've not had a chance to, I've not had a chance to upload. So I'm doing this while we are doing this, but I will make these available so you do not have to pay for them. Okay. I went ahead and we will scratch it out for you. That way, I know people have talked about it. You don't need to pay for essentially what, 185 pages of document. You know, I've seen people talking about it, and I'm like, nah, you know what? We got you there. If you like what we do, though, and you want to support what we do, hey, you know what? By the way, somebody gave me a bottle of Coke. I have not had any caffeine all day. I've been drinking like a tiny bit of caffeine on the day. So I'm going to drink a tiny bit of this caffeine, and it's going to wake me up. I'm going to be crazy. Oh, Lord. But this will be good. This is actually a pretty interesting document. Like I said, we have, let's see, I'm going to put them both up here so you can see what I'm talking about if you're wondering. So we have number one, we have the appeal document itself. We have the initial brief of appellate, which again, if you've been keeping up, is document 15, you know, and I noticed some people talked about when they were going to look it up and find out. I mentioned the document came up. I was so tired yesterday that I mentioned that something big had come up, but I didn't realize, like, I just left it laying there. And we were like, what's going on? And then there's this 85-page, again, the appendix. And it's one heck of an, like I said, I'm going to put both of these out there. That way you guys don't have to pay for them, because that's a lot to pay for. So I'll be dropping the link in a little bit. It takes it a minute. I'm uploading now, like I said. Now, a lot of this document, you know, one of the things that you have to understand with a document of this type is you're going to have one heck of a table of contents. And I mean, it's a monster briefing with a monster table of contents. So part of the 70 pages that will be thrown in there, of course, is it's going to look like this. You can see it on the side over here. Excuse me, I'm taking a drink there, but you can see it on the side here. It's quite the monster through this table of context. Of course, you're going through, you're going to have your jurisdictional statements, your statement of the issues presented for review, your statement regarding oral arguments, statement of facts, statement of argument, the standard of review, the argument itself, you know, what exactly this is, what exactly they're going to be arguing here. You know, and it breaks down, again, the sections. Like I said, we'll look at these too. I'm just showing you what all is contained in this monster of a document, because it is. So, you know, with that, sections, they argued the section areas. Then what happens with the courts, you know, and then section or part 2 here, the district court inferred by dismissing appellant's procedural due process claim by misapplying the legal standard, conflating substantive and procedural due process doctrines, and failing to accept well-pleaded factual. This is an important thing, by the way. When you're talking about something like this, courts are now here trying to set new standards. They are trying to look at something that has been, and you'll notice these terms come up over and over again and stuff like this, well pleaded, you know. They want some basis to go off of. They do this in all these types of cases. You know, you'll see them. If you read about lawsuits that come up when they're going after the police, you know, or a township or whatever, when that comes up, again, you're looking at something that, again, has been well pleaded. So breaking down exactly what is part of that too. All of the portions. Again, this is a long document. Just to note, it is a very lengthy document. 3, assistant state attorney performing investigation functions are law enforcement personnel. I like this too. They're saying essentially with Dan Owen, hey, if Dan Owens is out here and he's investigating, that is above and beyond what he is supposed to be doing. That makes him law enforcement personnel. Now, again, when we're talking about something like this, these are very difficult type cases to win. You have, I'm going to say, almost no chance at the lowest level where this came from. Right away, something like that is going to get bounced out and quickly. That is because you are dealing with people. We covered another trial and talked about Afro Man and everything that happened to that guy. For example, he had his home raided. He had police come in on allegations by a confidential informant that were so absurd it's almost unreal. They said that he had a dungeon, for example, when he didn't even have a basement. Those kind of things. And of course, those claims, they were dismissed right away. Why? Because that's the way things go. That's how it is. I have seen some crazy stuff, and the only time that you typically have something goes forward, you either have a township that sometimes realizes they have a problem and they will try to settle right off the bat, but typically they figure it's our money, our money, not their money. So they can do whatever they want with it, and they can burn it as much as they want. And yeah. And then you have 4, the long-standing constitutional and statutory mandates, including the full faith credit clause and the Violence Against Women Act, clearly require officials to enforce out-of-state protective orders. So again, you can see what's going to be argued through this. There's the same kind of arguments that we have discussed before. This is just, it's going to be really packed. Again, just a note, there's a lot. So we are now, again, I don't want you to be afraid of the size of some of these freaking filings, though. That's why I'm showing you everything that pops up in it. And then I'm not skipping anything. One of the things that I do like to address and to note is that we do cover what is in filing. So let me reset this and we'll get into that. It's going to be fun. You guys are going to enjoy it. It's crazy. By the way, if you enjoy, like I said, you enjoy the channel, think about backing. Appreciate you. I see 8 of you so more. Appreciate you there. Yeah, I saw I did see the LP post. I will bring that up tomorrow. We'll bring that in. I figure this is going to be about covering this specific document because it is so freaking huge. And like I said, I am uploading it. I will drop it in the chat in a little bit. And also I will drop it on Facebook for you guys. Because again, you shouldn't have to pay for this thing. It's a monster document and it costs way too much. They do. If it runs up on something like this, if you guys see something like that too, just, again, if you all will note, I know people go ahead and pay for documentation a lot of times, we have to, but if you all will wait, we can save some of you some cost, by doing that. Again, that's part of when I say, hey, you want to back the show, when people are throwing money into to back and everything, that's part of it. That's part of the costs. So, again, we try to pick up stuff like this. So, all right, let's get into this. Give me 1 second. Man, Dropbox is being stupid. There we go. All right, it's starting now. I'm starting to upload them too. There we go. It's been weird. Like Dropbox has been a mess today. It wouldn't do it on my phone. While I was out, I tried to upload it too. But now, and I'm stationary, now it's doing it. It's just slow. It says it'll be about, Good God. It says it'll be 20 minutes for 2 documents. Are you kidding me? But we'll have them up in a minute. All right. So the preface here. The initial brief is filed on behalf, again, of, remember, this is Jeremy and George. This is just one of them. This is both of them because they were both covered under the protective order. That's the thing that you have to remember. Like, both of them were covered under said protective order that these idiots, Dan Owen here, would not give full faith and credit to. They go through a jurisdictional argument, which I'm not going to read you the jurisdictional argument. We don't, you know, as far as jurisdiction, again, we don't really need to hit that. All right. Now, they talk about timeliness on appeal. All right. So they talk about the Court of Appeals jurisdiction, you know, them having jurisdiction over this, timeliness of appeal, like how fast they need to appeal, So, and finality of the order and appellate jurisdiction. So again, you get the idea of what we're looking at. I'm not going to bog you down in the minutia of, again, a jurisdictional argument. If you want to, and I do encourage you to read everything. It's just, God, that part's boring. So let's get into this. The primary, so here's the statement of issue presented for review. The primary legal issue here. We're going to have failure to give full faith and credit to protection orders. You know, whether appellee Owen, a Florida state official, violated 18 U.S.C. 2265 by refusing to reinforce and or recognize rather and enforce valid protection orders issued by an Ohio court. Now, again, you will see specific, one of the things that you'll see through a lot of these, you'll see specific items like 18 USC. Let's see, 18 USC 2265. 1 second. I'll pull this up for you. Give me a minute. So 18 USC 2265. It's about federal law about protection orders, or restraining orders, if you want to call them that, and how they must be honored across state lines. I mean, in plain English, this is the way that it notes. What does this mean? It requires that a valid protection order issued in one state, whether that's tribal land, territory, state, whatever, it must be recognized and enforced everywhere in the United States. That's where you get full faith and credit. So when people say that all the time, that's what that means. Like, if you're curious about what full faith and credit means, it's saying you give this that is issued in Ohio, in this instance, full faith and credit like it was issued in Florida. I think it's a pretty cut and dry issue. I don't know why these people think that they don't have to do that. Because, I mean, what it would mean again, you have one state, another, the police, they have to treat it like their own order. They can't pretend that it's the way that they have pretended that it's from another state, and they somehow don't have to do that. That's absurdity. You do not have to refile in a new state. You have to file one place and it's valid in another place. And the way they have treated it, it's like, you know, it's like a monopoly money or something. Like, you don't have to. And the absurdity to that, again, and that covers stalking harassment orders. That covers orders protecting DV protective orders, partners, children, family members. And the reason that this matters, by the way, is because that closed a giant loophole in the law. When that was brought up, there was a giant loophole, because essentially somebody could come in, they could cross the state line, and they could ignore restraining. You think about the insanity to that. I mean, the insanity to it is, you had before, if you're not giving full faith and credit, you have person A that get a restraining order like this in Ohio. Person B, they end up traveling to Florida, and person A travels, person B travels, or they're there, whatever, and person B violates, well, then they're supposed to be arrested, Now, an important detail, states cannot require registration also of an out-of-state order before enforcing it. They did register, they did note it there, but they can't offer it. So they even went to that level too. They told them about it. They made sure that they understood, but it's in full effect no matter what. If they call in, they tell them it exists, and these people are violating, they're supposed to, that should be it. But they didn't care. So just to explain this whole fiasco, this whole mess, that essentially is what this boils down to. So federal right enforceable through Section 1983, with the full faith and credit clause of the United States Constitution and its impending statute, 18 U.S.C. 2265, creates a federal right enforceable through 42 U.S.C. 1983. 42, I like, since we're here ourselves, we can actually pull these up. I've pulled them up. I've made notes of everything so you can understand what they're all about. This 42 USC 1983 here, it creates a federal right enforceable through. Now, what is this, you might ask? What does this mean right here? Well, it's essentially one of the most powerful civil rights laws in the United States. It's basically the tool, like when you look at it, that people use to sue their government officials for violating constitutional rights. So when you see key phrases like under the color of law, you file a federal lawsuit. This lets you file a civil lawsuit when someone acting on behalf of government authority violates your rights. Again, the key phrase you hear people say a lot is they were acting under the color of law. Now, you can sue for all kinds of stuff under this. This is where you have your common examples of suing police for excessive force, unlawful detention, free speech violations, due process violations, illegal searches and seizures, and so on. With that, you can sue all types of government officials, everything from police officers, court counting entities, to prosecutors. And what can you get from that, you might ask? Well, you could have injunctions, attorney fees, monetary damages. The one thing, and this is the huge hurdle in this, and this is what they run into, and the argument that Dan Owen put forward, is qualified immunity. You will see officials, they're often protected unless, and this is what has to come up, they have to violate clearly established law. Okay, so that's where a lot of the arguments come from. I want you to understand that, since you and I are just sitting here talking about this. Now, also, whether appellee Owen investigation into the truthfulness of plaintiff Hale's statements in obtaining the Ohio protective order violated the statutory mandate to enforce foreign protective orders, quote unquote, as if they were orders of the enforcing state. Again, they have to look at it like it came from their state. Is it normal for a person to say, well, you know what? I'm going to look into this protective order right here, and I'm going to investigate the person that got it to see if they perjured themselves or they had any problem with it. Is that typical? Would they do that if that were a Florida protective order? The answer, by the way, is probably not. There's a bunch of bullshit. So violation of procedural due process rights, 14th Amendment and 14 U.S.C. 1983. So whether when evaluated under, again, you have the plausibility standard here. Now, again, we go over all types of stuff through this, and somebody asked about this. Like, what exactly does this mean? Essentially, this plausibility standard is when a rule court is used to decide, is the lawsuit detailed enough to move forward, or essentially is it just speculation? Now, this right here governs federal proceedings under Rule 8. It's one of the biggest gatekeepers in civil cases, especially 1983 claims. Okay. So when you're looking at it, that's what it's talking about. It's not one case. I believe it's two cases. I didn't. There are two, I believe, 2000 cases. Again, God, it's been a minute since I've looked over all these core rulings. But they look at a two-step test they use to throw out conclusions and to look at actual facts. So when you see this, again, we saw this in the last one, in the original, and I don't know if we even talked about what that meant. So that, the plausibility standard, and controlling the 11th Circuit precedent, appellates have stated a factually plausible claim for violation of procedural due process. So qualified immunity question. Whether Dan Owen, is entitled to qualified immunity for his conduct in refusing to enforce an Ohio protective order and investigating their validity. Also, whether the requirement to accord full faith and credit to protective orders under 18 U.S.C. 2265 constitutes clearly established federal law, such that a reasonable official in the appellee Owens' position would have known his conduct violated plaintiff's statutory and constitutional rights. That's a huge question in there too. When you run into it, this qualified immunity slams up against that, and we have questions about how does that work. The absolute prosecutorial immunity. Also, the question here, whether appellee Owen, as a state prosecutor, is entitled to absolute immunity for his conduct in investigating whether plaintiff Hales committed perjury in obtaining the Ohio protective order, whether such investigative conduct constitutes an investigative function not entitled to absolute immunity, or a prosecutorial function entitled to absolute immunity under established legal standards. Now, this is an interesting question too. When he's doing this, when he's saying, hey, we need to go in and investigate, is that an investigative function or a prosecutorial function? Why does that matter? Well, if he's a prosecutor acting under prosecutorial function, then that would potentially entitle him, or would entitle him, to absolute immunity. These people enjoy immunity from so much. It's insanity. No other function out there, anything you do looks like this. But for them, it does. But if it's an investigative function that falls outside of their purview, then they are not entitled to absolute immunity. And also the full faith and credit clause, whether states must accord full faith and credit to protective orders issued by other states without reexamination or investigation of their validity. See, that's a crazy idea too. When you're talking about full faith and credit, are we talking about something where they just have to accord it? Do they actually get to investigate it? Because again, the idea that they're investigating a protective order, if it was launched in Florida, that would be absolutely insane, with that. Oh my God. That's funny. Wait, do you think Potted Plant, do you think Bolitho is on the 11th Circuit too? Do you think he's there? Is that what you think? Because the Potted Plant thing is about Bolitho. So do you think Bolitho is somehow tied to this? Is that what? Maybe you should spell that out a little bit better there. I like it. I've had a protective order before. And I tell you, like here's one of the things too. Protective order isn't just about protecting myself. It's about making me not have to do something else. The courts are supposed to stand up, and they did. They said something about that. And then the police are supposed to, as the functionaries They're supposed to step in between it and not make me have to do something terrible because one of these people, they won't stop. And if they won't stop, you put yourself in a position where something horrific may happen. So again, I think all these flunkies that are out there that, you know, that think that these morons out here, they somehow in some way haven't been accorded every chance to stop and everything. Again, that these people, they went and they got a protective order. They went the way that you're supposed to go. But for some reason, some jackass little town that has a very bad track record of treating all types of victims terribly, they decide, hey, guess what? We're going to treat these victims terribly too. But I suppose all those flunkies out there, I suppose when you're happy with Levy County and the way that they interact, I suppose those art victims and stuff that they have been notorious in Levy County for kicking to the curb and making deals with people, that they've been called out on an international, not just a national, but an international level. I guess you're okay with that too, right? Or you just pick and choose your fights. See, that's the amazing thing, you know. It's awesome. I love it. Remember, for the antis, like the Fats, for example, the Fats, all prosecutors are trashing stuff when they're talked about her husband, for example. That piece of shit that fucking defrauds old people and stuff. Oh, that's somehow wrong. That's terrible. All prosecutors, but this prosecutor, they're great. What a bunch of suck ups, man. You like that jackboot on your neck, you enjoy it. But these people, they are our employees. And if they're not going to afford people protections there, they should be called out for it. And if you don't see that as a problem, if you don't see the problem in some morons from Florida, a couple of half-wits that live across the street from somebody with a protective order, giving video to some weirdos that are in, I mean, there's some of them are in Florida. Who else? Who knows who else they're giving it to? But you don't see a problem with that. So you can publish that online for continued harassment and defamation. It's funny how they think that all of this stuff there is a problem when it pops up. And, you know, when somebody talks about, I don't know, interviewing the Fats neighbors. Oh, my God, that's harassment. Really? Because they did that to Hales. The only difference is when they came there, they came under permission of somebody that had a protective order against it. So, again. But again, you suck up to that jackboot. You enjoy that. I love these morons. I love how hypocritical they are on it. So let's continue. Also 7, the standard, the state official liability under 42 U.S.C. 1983, whether a state official acting under the color of state law can be held liable for violating federal statutory rights under 42 U.S.C. 1983, and relief issues. Whether the district court erred in dismissing the plaintiff's claims with prejudice, despite plaintiff requesting for leave to amend their complaint. So the statement regarding oral argument. So pursuant to federal rule, again, you can see the rules here. The appellants respectfully request oral argument in this appeal. Oral argument is warranted for the following reasons. Number 1, complexity of the legal issue. This case involves significant questions regarding the interpretation and application of federal statutes, including 18 U.S.C. 2265, that'd be the full faith and credit provisions for protective orders under the Violence Against Women Act, and 42 USC 1983. It's funny, I started combining the two. Specifically, the appeal raises issues about whether a state official's refusal to enforce out-of-state protective orders constitutes a violation of federal law and substantive due process rights. These issues are novel and require careful consideration of statutory language, legislative intent, and constitutional principles. So clarification of factual and legal disputes. The district court's dismissal, or rather dismissed plaintiffs, appellants, claims on the basis of Federal Rule of Civil Procedure 12b-6, finding that the allegations failed to state a plausible claim for relief. Appellants, I'm just going to call them the appellants. We don't need to go with both, because you understand that they're the plaintiffs. They are appealing in this case. They contend that the district court misapplied the pleading standards under. So again, you have, remember the two-prong that we were talking about, the plausibility standard. They're saying, well, they're contending that they misapplied those pleading standards there. The oral argument will allow the parties to address the sufficiency of the allegations in the complaint and clarify how the facts as pleaded support the claims under federal law. 3, importance of issues to public policy. The enforcement of protective orders across state lines is a critical issue affecting the safety and security of individuals who rely on such orders for protection from harm. Yeah, of course, again, anti-morons don't understand that they're like, violence against women? Jeremy Hales isn't a woman. Well, first of all, there is a female that is part of this. Second of all, that doesn't mean shit. And anybody that comes across with that excuse is the biggest morons out there. I can't believe that there are 2 morons, in fact, that are part of this. One of them pretends to be, or both of them really, they pretend to be journalists, but one of them also was out there as part of, as part of legal proceedings. Was a lawyer himself, and he was such a jackass that apparently he and his partner can't understand how the Violence Against Women Act actually applies to everyone. It doesn't just apply to women. That has been one of my favorite things that I have seen out there. We casually just walk away from that, pretending that wasn't one of the stupidest things I've ever heard in my life. I bring that up every time, because those people, them commenting on any kind of case, I think that pretty much tells you cases are very difficult. Cases are very difficult to win. They are very costly to bring. They're very difficult to win, and they become even more difficult when you go after any of these officials. I want to call them officials, I guess. But you're talking about, again, police officers. You're talking about prosecutors, whomever, judges. Holy crap! Having a judge do something wrong. Sometimes you'll find a judge that they say does something wrong, but even then, you notice nothing ever happens to them. They're biased. They're horrible. Nothing happens. But again, like I said, some people love their jackboots. As long as it protects their delicate fees, because we're not talking about a speech. This isn't an issue that even really talks about Lynette Preston, and it doesn't talk about John Cook. It talks about the enforcement of a protective order, like just the absurdity. Imagine I get a protective order, and I'm in another state. I go there because I have a business there. So I travel. And when I go there, instead of applying my protective order, they do 2 things. Number 1, they tell people that they're going to investigate the person that brought it, which is absurd and insane to do. Would they do that if it were a Florida court? Would they investigate that? Or again, would they have the stones to do that with a federal court? And the answer is probably not. But on top of that, the other part of it too is the idea that they would tell other people not to enforce it. There is still a letter out there. They're playing a game. Now, the antis are, like I said, they're some of the dumbest people I've ever seen. And you have people like, here, I'll give you an idea. I'm going to show you a post. This is what these people think. This is how they think it works. They think that there can't be a letter or anything else set on. Why? Because, with FOIA, if you request FOIA, I'm going to show you this, and then we'll go back to our document. If you actually request a FOIA document, they have to give it to you. Here's one of the dumbest human beings on the planet right now, in my opinion, Marla Hughes. You can file FOIA and get them even if you're under investigation. How would anyone get documentation from government officials otherwise? Now, again, that is one of the dumbest statements. Yes, you can file, and sometimes you can get something, but more often than not, if there is an investigation going on, or they can use that color of law to keep you from picking it up, then they will. There are exemptions in FOIA. The FOIA Exemption 7A specifies that federal agencies, they can withhold records or information compiled for law enforcement purposes if the release could reasonably be expected to interfere with ongoing or prospective enforcement proceedings. Now, what they'll do with that oftentimes, if they have something that makes them look really, really bad, like say a letter where Dan Owen tells police, hey, you shouldn't enforce that, they'll pretend that they are investigating forever. They will, quote unquote, keep something open and keep something open until, again, until any problems they have, they feel like they're in the rear view mirror. And they do that a lot, by the way. That doesn't happen not with just Dan Owen. They do that a lot. That's one of those cover your ass kind of moves. And things rarely happen to these people when they do that. It's kind of crazy. Let's move that over. Let's make that look bigger too. So the importance of the issues to public policy, though. Again, the enforcement of protective orders across state lines, critical issue in affecting safety and security of individuals who rely on such orders for protection from harm. This case presents an opportunity for the court to address the scope of obligations imposed on state officials under 18 U.S.C. 2265 and the constitutional implications of failing to enforce such orders. Oral argument will assist the court in evaluating the broader implications of its decision on public policy and the enforcement of federal rights. I also think every voter should see what Dan Owen and his bosses, their excuses in the original case for why they don't have to do it. They should read those. Every person that could potentially be in danger, everybody, read. They don't owe you shit. That's essentially what they said. They are there to protect you, and yet they don't have to if they don't want to. That was their argument. So, interactive nature of oral argument. The interactive format of oral argument will allow counsel to respond to the court's question in real time, particularly on nuanced issues such as the applicability of prosecutorial and qualified immunity, the interpretation of law enforcement personnel, like what that means under 18 U.S.C. 2265, and a procedural due process analysis. This will aid the court in resolving any ambiguities in the record or legal arguments. 5. For these reasons, the appellants, they respectfully submit oral arguments will significantly aid the court in its decisional process and request that the court schedule oral argument in this matter. So the statement of facts. Again, we are talking about Jeremy Hales and George in this matter. They're Ohio residents, right? They obtained valid protective orders from Ohio court October 30th, 2023, and after a hearing on October the 10th, 2025, where Preston and Cook, the people against whom the protective orders they were issued, had reasonable notice and opportunity to be heard. Preston and Cook, they both attended the hearing via video conference. They represented themselves. The issuing court had jurisdiction over the parties and subject matter under the laws of Ohio. Now, under 18 U.S.C. 2265, the appellee, that would be Owen, was required to give full faith and credit to protective orders to enforce them as if they had been issued in Florida. Now, Owen is an assistant state attorney for the 8th Judicial Circuit State Attorney's Office. Now, instead of enforcing the protective order as required by federal law, Owen recognized the opportunity, or recognized the, here we go. I messed myself up here. Owen refused, rather, to recognize the validity of the orders. I need a little more caffeine for my brain. Give me a second here. Oh, this occurred via an email dated 10/30/2023, in which Owen initiated an investigation into whether Hales had been truthful in obtaining protective order in Ohio. Yeah, why the fuck would that happen? Like you notice, like, these people, when they're defending this idea, again, if it were reversed, would they find this would they find that okay? Would they? Do you think the Fats and all their little pals out there, do you think Preston and Cook, they would be screaming that if somebody said, hey, let's investigate them if they had a protective order, do you think they'd be like, yeah, way to go, prosecutor? Absolutely not. Fucking frauds, disingenuous frauds. So Owens' email was sent in response to an email by an idiot that decided that he was going to show up at the Ohio protective order, the last portion, which wow, that's going to be a real good transcript. By the way, tomorrow we're going to finish off. There's a video that we have not watched that is part of that. We will finish off. That will be, he's the undersheriff and legal advisor for the Levy County Sheriff's Office. So you have the undersheriff. Again, I'm going with position here. Oh, Brett. He is an undersheriff. He is a legal advisor. And his freaking idea is, yeah, let's not investigate, but we're gonna investigate the guy who has that. And again, they're gonna come out and they're gonna defend contact. They're gonna defend things like flipping off somebody. Again, remember, flipping a person off is speech. That action is speech. So if you flip someone off and they have a protective order against you, you are making contact. That is speech. That's something that, again, morons don't seem to understand. When someone rolls down a window, when they make a statement, that is obviously speech. That is a violation. And these people admitted that happened, but they were like, well, it might not be a flip off. He might be stretching. Oh my God. What a bunch of idiots. I'm telling you, even beyond the hearing into whether or not they were violations, that just the absurdity for them to defend these people and to say, well, maybe, or for them to admit that something went on that was contact and then not to do anything anyway, for them to say that they looked at the totality of the circumstance rather than, the violation is the totality of the circumstance. It's just crazy. But anyway, I rant about that. So he wrote them. So we have Dan Owen writing to the undersheriff / legal advisor for Levy County Sheriff's Office with the subject line, need some help. And he asks, can you email me the petition that, again, Hales filed in order to obtain an order of protection? If you don't have a copy, please request one from the clerk of Summit County. I want to see if he committed perjury in the petition. Specifically, I want to see what representations he made with reference to residents. My understanding is that he has no ties to Ohio, much less Summit County, Ohio. So, on or about November the 11th, 2023, George reported protection and enforcement of the orders to Williamson. That will be 710 of the Levy County Sheriff's Office, who stated in his report, listen to this quote. I don't know how to make this any clearer than this right here. I reviewed the assistant state attorney, that would be Dan Owens' email regarding this matter. This is an email outside of it. We don't have, because again, I believe they're setting on it and they will not enforce it under FOIA. In fact, they have come back and said that they will not turn over everything because there's an active investigation. They have had that thing going on for longer than the state allows an active investigation to go on. Why? Because they're covering their ass trying to avoid this. It's bullshit. It is absolute bullshit. They are sitting around longer than it is allowed by law to keep this type of investigation open. But again, they are trying to hide an email. How do you know? Because this officer says, I reviewed Dan Owens' email regarding this matter, and it reads that he would caution against the enforcement of this injunction. That's not what the other said. So that means there's another email. An email they won't turn over because it is a smoking gun, and you know it is. If there's something out there that is saying that he's cautioning against enforcing this, are you fucking kidding me? And they will not turn it over in FOIA. They refuse to. They say it's part of an active investigation. An investigation that's been going on forever. That is 100% factual, by the way. They are fucking lying. They are lying. They are doing that. All of the laws that are supposed to protect against stuff like this, they're the people who enforce it. Again, it goes back to that whole who watches the Watchmen. Apparently nobody. That's what you're asking an appellate court. Hey, this is pretty jacked up. So, saying that, George here was made aware of this and was told this report would be for documentation only. Imagine that, by the way. You go in and you say, hey, these people are violating protective order I have. And the cops come back and say, hey, the prosecutor here, he says that we can't enforce it because they're saying that's what they told her. Like, imagine how fucked up that is. Imagine what you're being told in that moment. You're on your own. So when Levy County has the audacity to say people are not in fear for their lives, they create the fear. Dan Owen creates the fear because they're telling you that the police, they will not help you, even though you've gone through all of these legal freaking loopholes, all of this bullshit that you have to. You've jumped through all the hoops. You've done everything. But nope, you can't get justice in Levy County. So George was advised that she had a video of the event, which I'll attach to the report when it was provided. So the appellants allege that Dan Owen acted under the color of state law. On or about October 31st, 2023 to May 1st, 2024, both plaintiffs were present in the state of Florida, Levy County, on at least 3 occasions beginning in November 2023, presented the protective orders to Levy County sheriffs requesting enforcement, and each time enforcement was refused based on Dan Owens' position. Owens conceded in his motion to dismiss that he was investigating the Ohio court's jurisdiction. So he did. He said, yeah, I can do that. Fuck yeah, I did it. Instead of enforcing, he investigated whether or not they have the power to do it. What the fuck, man? Why? Why? What gives him the right to go in and second guess the Ohio courts? Again, full faith and credit. It's like a Florida court did it. Would he do that? Would he have the stones to do that to a federal judge, a Florida judge? No, absolutely not. The appellants filed a complaint 9/21/2025 alleging they had suffered physical harm, threats, emotional distress, fear of death or bodily injury, and financial harm. The district court dismissed the complaint for failure to state a claim on December 19th, 2025, concluding 1, Owen was not law enforcement under 2265, and the complaint failed to allege what Owen was supposed to do. So again, it was pretty clear. Owen also, what's jacked up in his claim, he lists items and says, well, this proves we were going to. We actually were enforcing it. Well, first of all, some of the stuff they noted in there as proof, they never went forward with. So it actually, some of it had nothing to do with this particular thing, and some of it had there was no enforcement. They decided, nope, not going to enforce that anyway. So kind of weird when they were like, look, here's our proof that we've not done anything wrong. And it's like, wait a minute. And 3, there's no plausible claim based on 2265. Four, the most obvious problem with appellant's claim is that they, quote, have pleaded no facts plausibly suggesting Owen nullified anything. Now, here's the question. How the fuck do you showcase anything better than that? There's no proof that he nullified anything. Are you kidding me? Again, all those morons sitting over there looking at this as fuck Hales. Well, if they were looking at this again reversed, you tell me, what does this letter state? Does it not say when he's telling them not to enforce a protective order? That doesn't mean in this particular circumstance. It means any of them. So no matter what these people do, you have Dan Owen cautioning against it. It doesn't matter if they freaking they make contact, they pull a weapon. It doesn't matter. He's cautioning them. How the fuck is that not nullification? You have a prosecutor that's saying we won't prosecute. So why would the sheriff's department, why would they do anything? They're being told not to. It's not an implication. That's just straight up fact. That's what this person is saying. He told George that too. And he wrote it in a report, which is insanity. And 5, even if Owen asked for a copy of the documents and pondered whether the appellant obtained the order unlawfully, that did not nullify any valid order and, quote, did not preclude the court or law enforcement from acting on the order. Law enforcement, like I said, noted that. It's insanity. And 6, again, though, that's the way local courts, and honestly, courts don't like to step out. If you want to see how appellate courts, how stupid some of them are too, again, I would encourage you folks, if you want to wake up to how broken your systems are, go and watch channels like, again, Lackluster. They talk about police, not only about police, but claims against them. There was a guy that, just to tell you how stupid these freaking people are in appellate courts, there was a guy who was videotaping on a sidewalk a police department from the outside. Okay? The outside, which you 100% have the ability to do. You can record anything that is public, you know, got a sidewalk there, 100% public, and also it's the outside of a building. So cops come out. They want to know what's going on. They want ID. Dude tells them I'm recording, you know, because I'm putting together a story. The same thing you hear from so many folks. They arrest him, right? They demand ID. They have no right to ID, but they arrest him. Now, their thing is, well, maybe he's doing something terrible, which is an absurd argument. And the appellate court, they not only said, well, the police, they, you know, because bad things happen, you know, some people do terrible things, therefore maybe it's okay, which is not. There's case law that already cites that's wrong, but they also take up for the idea of Terry stops, you know, stopping someone and demanding ID, which is not legal where they were at. It is some of the most frustrating stuff you can ever see. And it's already established, but they defend it anyway. So when you look at courts and what courts do, even with appellate courts, this stuff is beyond frustrating. It is hard to get justice. It is. I have to commend Hales for trying, period. This is the hardest thing to win here. But like I said, there are a lot of people out there that enjoy that freaking boot on someone else's throat. They wouldn't enjoy it on their own, though. So, Again, this appeal follows after all this. So the summary of the argument, 18 U.S.C. 2265, they'll just call it 2265, creates a private right of action and enforceable rights under 42 U.S.C. Section 1983, which they'll call Section 1983 or 1983. The district court improperly applied Rule 12b6 pleading standard. So the standard of review. An appellate court requires de novo the district court's grant of a motion to dismiss under, again, 12b6 for failure to state a claim, accepting, and people don't understand also. It seems like they're morons. They don't understand what this means either. It amazes me because when they describe it worse than a layperson. That's what blows my mind. It's not a statement. They make it sound like there was nothing that was written. It's the dumbest stuff I've ever read. Like, oh my God. But I'm talking about idiots that don't read documents. They just tell their army of the freaking just sick. I mean, they're like a cult at this point. It just blows my mind. I hope, by the way, just as a statement, I hope that people understand too, with all of this, that Hales did try to go through the process of court. And through that, the antis, they have said it's fine to do many terrible things, like videoing anything that Hales, who had a protective order, George, who has a protective order, people that are around them, anything that they do from people that have protective orders against them, again, just crazy shit, stalking these people. They've said that going after friends, families, neighbors, that's okay. Trying to dig up any and everything that would try to damage or defame, that would work. Going in and then utilizing that to target platforms, to target individuals who spend money, to target advertisers, to target jobs and more, that's okay. So Hales went through the courts. And if the courts say that that stuff is okay, that goes two ways. I myself, and I'll make this very clear, I'd return the favor then. I'm not Hales, but I would return the favor because fuck these people. If they really wanted to see doing something for YouTube clicks, I would show them. That's just me. They'll be like, oh my God, he said something's a threat. No, it's returning exactly what they did. They don't like it. They don't like the idea that you might interview their neighbors. They don't like the idea. They sit on their cameras and they peek out hoping to God somebody's not going to do the same thing that they've done to other people. It's weird. And again, don't bother these people. I'm not saying you to do that. Don't. But Hales, oh yeah. If courts are saying it's all good, it's all gravy, why not? So anyway, accepted the allegations and the claim is true and construing them in the most favorable light to the plaintiff. That's how you're supposed to look at something, You're supposed to look at complaints as if they're true and you construe them in the light most favorable to the plaintiffs. That's how anything is supposed to be looked at. So the claim must contain sufficient factual matter, accepted as true, to state a claim to relief that is plausible on its face. Again, you have case cited. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Again, you've already seen this over and over again as part of, again, our two-pronged testing. All reasonable inference are to be drawn in the plaintiff's favor. So the argument here, again, number one, Section 2265 creates individually enforceable rights under Section 1983 because it's a mandatory command that protection orders shall be accorded full faith and credit and enforced uses unambiguous rights creating language with an unmistakable focus on individual beneficiaries, directly satisfying the Supreme Court's requirement in the 11th Circuit's three-factor test while providing no alternative enforcement mechanism. So again, if you're looking at this, when they're saying this, they create mandatory command. That means you have to enforce it. It's about full faith and credit and enforcement of protective orders using unambiguous rights creating language. So you cannot misinterpret what it means. With an unmistakable focus on individual beneficiaries, that's the people that are protected, satisfying Supreme Court's requirements in the 11th Circuit's three-factor test while saying there's no alternative. This is what you must do. There is no other way to go about it. So to state a claim under Section 1983, a plaintiff must, 1, allege the violation of a right secured by the Constitution and the laws of the United States. 2, show that the alleged deprivation was committed by a person acting under the color of state law. Again, and going through. This is all, again, I will, through this, what I'm going to do is instead of reading the historic case law, this is again citation, all right? I'm going to skip some of this. I would, if you are not familiar with any of the arguments and how they lay out, we have looked at stuff like this before. So I will recommend that you read over all of that. Okay, you should always read every document. Don't take anybody's word for anything. Okay, take your own word. But I am not going to read every single sentence on that. You know. Oh yeah. Yeah, of course they would enjoy the boot on their throats. Would you expect anything less from bootlickers? That's true. They are bootlickers. They actually are. They're boot blacks. They really are bootlickers. Isn't that interesting? Maybe this is a fetishization of something. Maybe they actually like the authority pressing it on their backs because they are fetishists. So they enjoy licking the boot. No joke. That's for real. Tory Jones, not real name. That's what they are definitely about. You know, you've ran into some interesting folks out there. And again, if that's your thing, awesome. But I don't think you should confuse it with somebody stepping on your rights. You know? So the Supreme Court's test for determining whether a statute creates an enforceable right under Section 1983 requires that the provision in question be phrased in terms of persons benefited and contain rights creating individual-centric language with an unmistakable focus on the benefited class. Yes. So again, unmistakable, focusing on the individuals that with an unmistakable focus on a benefited class. So if a statutory provision surmounts this significant hurdle, it secures individual rights that are deemed presumptively enforceable under 1983. Now, in the 11th Circuit, the court applying a three-factor test to determine whether Congress intended the provisions in question to benefit the plaintiff, whether the statute, 1, creates right-creating language that is individually focused, 2, addresses the individual or the needs of the individual person being satisfied instead of having system-wide aggregate focus, and 3, lacks an enforcement mechanism through which the aggrieved individual can obtain review. As will be shown, Section 2265, 1, unambiguously benefits individuals protected by protective orders. Number 1, so makes it very clear. 2, contains rights creating language focused on individual beneficiaries. And 3, satisfies the requirements established by the Supreme Court and applied by the 11th Circuit for Section 1983's enforceability. Again, they talk about full faith and credit. Here, there's the Interstate Enforcement of Protective Orders under the Violence Against Women Act of 1994. And that notes regarding concerns where a victim of abuse who left the state in which a protective order was issued would lose the benefit of the order and would need to seek a new order in another jurisdiction. So this has been talked about there, the full faith and credit. This idea, section 2265, it brings up that section, full faith and credit. Without going over everything, it essentially is saying that, again, if it is ordered in one place, one state, it is ordered tribal territory, a tribal area or another territory, that issuing place, it shall be accorded full faith and credit by the courts of another state, tribe, territory, whatever, et cetera, et cetera, et cetera, Oh yeah, Jack's mom. I'm telling you, like for me, I'm just for that sending Doug to Florida. I'm telling you, if it were me, I am fucking petty, and if somebody wants to burn down my life, I would make a business out of looking into theirs. That would be my response. Again, they've tried to do that to everybody that has been around Hales, and many people have backed away from them. That is why Hales went from, at the beginning of this, Hales went from giveaways publicly with everything else to having to lock his life down, and George having to lock her life down, and then protecting the people around them. It's a sad reality that has been created by just utter pieces of shit. And again, I would make sure that no one ever forgot who they were. Ever. People like Miltos do. Any of these people on the outsides, I never let them forget. I'd remind them all the time. Be like, oh yeah, what was that thing you got that big shot for, buddy? What was that? Okay. So section 2265 mandates that protective orders issued in one jurisdiction must be accorded full faith and credit by other jurisdictions and enforced as if they were issued by the enforcing jurisdiction. The statutory command is not directed at abstract governmental interests or system-wide coordination, but rather at ensuring that individuals who have obtained protective orders receive the benefit of those orders, regardless of where they travel or relocate in the United States. That makes perfect sense, right? The statute's focus on protective orders themselves demonstrates the individual-centric nature. Protective orders are inherently personal legal instruments. When we get to the bottom of this, I'm going to read some super chats, and then you can comment while we're going through this, because I'm by myself as we go through this, so we can have this more like a conversation. Protective orders are inherently personal legal instruments obtained by specific individuals seeking protection from specific perpetrators of domestic violence, stalking, or harassment. That is true. They are personal legal. Like I said, I've had one. I can't imagine. You know what, though? It's hard enough to get anybody to give a shit. It is. It absolutely is. And then for them to play it like this is crazy. Let me do this. It won't take me just a minute. But I would like to. No, you know what? No. I'll catch some that come in. You know what? That will interrupt our flow. I will read as they come in. I'm looking to see if any of these have brought up anything. I will catch them all. Okay, and I do appreciate everything everyone said. I will catch them all accordingly. But if you bring up one that has something specific, questioning or a comment on that, I will definitely hit it then. Okay, I think that sounds fair. That way I don't, because and again, I appreciate the heck out of all of you that are here. I know it's a Saturday. You all have many things in your life, but these things matter. They do. They absolutely matter. And it's horrible that this has gone on as long as it has. So by requiring full faith and credit for these orders, Congress necessarily focused on individuals who obtain them and depend upon their enforcement for safety and security. So section 2265 uses mandatory rights creating language that again, unambiguously confers enforceable federal rights on individuals holding valid protective orders, distinguishing it from statutes with merely, so again, looking at all of this, blah, 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 right? What this is saying is, again, this creates mandatory, again, rights creating language. That's important. Rights creating. You have the right to. That unambiguously, you cannot read it another way. It is very cut and dry. There's enforceable federal rights on individuals holding valid protective orders, distinguishing it from statutes, again, that are with policy-driven terms, et cetera, I think that's pretty easily understood. So rights creating language is language that is explicitly conferring a right directed on benefiting classes of persons. That includes the appellants in this case, or language identifying the class for whose benefit the statute was enacted. So again, this creates, it's language that explicitly confers a right on a benefited class. That includes Jeremy Hales, that includes George. The question is not simply who would benefit from the act, but whether Congress intended to confer federal rights upon the beneficiaries. A statute must be couched in mandatory rather than. So again, when you're looking at language, with this, you'll see a language pop up and wonder what exactly it means. You're talking about, again, it's mandatory versus relating to or expressing a wish or request. It's saying must do versus want to do. That's what you're getting through that. And again, it created mandatory language. So the provision giving rise to the asserted right, again, goes through the same thing. So the court, having long recognized that the pertinent question in determining whether the statute provided a basis of 1983 suit, whether Congress intended to create individual rights binding on states, as opposed to. So again, when they're going through this, the question is, what was Congress doing here? And when the question rolls down, it's in the way language is utilized. And all of this is an important argument, okay? Because look at how this is described here. So section 2265 employs mandatory language requiring protective orders must be given full faith and credit. It's cut and dry. You can't, it's mandatory. They have to, and enforced by other jurisdictions. This is not permissive. This doesn't suggest that they may honor. Again, this isn't a suggestion. This isn't saying, well, you can. Rather, it is binding language that is unambiguous, saying that they have an obligation. Courts, law enforcement must recognize and enforce validly issued protective orders. This means that it's mandatory. It's distinguished, that it distinguishes Section 2265 from statutes that merely establish general policy goals or provide guidance. It's not guidance, it's establishment. It is a must do rather than a, well, maybe you should do. Congress did not suggest or encourage full faith and credit. It ordered it. I like that statement. It ordered it. It said you must do, not, well, if you feel like it. The mandatory language demonstrates congressional intent to create binding obligations that protect individual rights. The benefited class is readily identified in Section 2265, persons who obtain valid protective orders from the court and of competent jurisdiction. The individuals are not incidental beneficiaries of a statute designed to serve other purposes. They are the direct intended beneficiaries. Again, yes, this isn't, well, these people, they also get this, but rather it was intended for them. you know? It was intended for them. I'm trying to describe it as we go along because I think the language of some of when we went through the original complaint, I think some of the language I'll get questions written, and I think these are written well enough anyone can follow. But I think there's good arguments in this, not just for it's education on how this is supposed to work. Period. Outside of the Hales case, you would need to understand your rights. These are ironclad rights there. Yeah, Andre, I agree. All of this happening to Jeremy and George affects everyone that they help, from kids at Christmas to helping the homeless with clothes. That's right. Jeremy and George deserve better. Indeed. You know, it is cut off, and those other people deserve better. All the people this could help. Think about how much money, how much help $500,000 could have done. I mean, think about that. And they've had to go into this, and these people, they pretend that it's not such a big deal. It's a very big deal. It is what's happened there. Miss Erica, yeah, thank you. That's good stuff. Levy County is the reason so many victims don't come forward. That's right. The fear that people we pay to protect us won't is a real problem. Yet not only that, they'll turn on you. They'll go into another court and they'll try to get you indicted. They'll testify against you. Like, think about how insane that is. You have to fear the people that protect you, that they'll go to a protective order and try to testify against you when the court itself is already established. Like, they tried to testify against things that were already established violations. They were like, no, we didn't find a problem there. The court's like, well, we did because they made contact. Oh, it's crazy stuff. Blows my mind there, you know? Yeah, see, I think this is a good statement too, because, well, first of all, thank you, and love to you too. Thank you for the love for the girls. But from Canada, people outside the U.S. are looking at this, and it's mind blowing because law enforcement actually causes us to lose respect and faith in them. Yes, I mean, you have outside jurisdictions looking at this and thinking, my God, would I ever want to be around this? Absolutely not. But they're directed and intended beneficiaries of Congress's mandate that the protective orders be honored across state lines. The statute's unmistakable focus on the benefited class is evident from its subject matter and operation. Protective orders exist solely to protect specific individuals from specific threats. That's exactly why they are there. A statute requiring full faith and credit for protective order necessarily focuses on individuals. Those orders they actually protect. You know what this means too? That people didn't enforce them at one time, and that you had to have the biggest governing bodies in the land step in and say, you've got to do it. So a statute requiring full faith and credit for protective orders necessarily focuses on individuals those orders protect, as they are the only persons with a direct stake in whether the orders are honored. That's exactly right too. Why 2265 is phrased as a command to jurisdictions to honor protective orders. This command necessarily creates a right in protective order holders to have their orders honored. Yes, the mandatory nature of the statute's language transforms what might otherwise be a general directive into individual entitlement. That's right. When Congress requires protective orders to be given full faith and credit, it creates a legal right in the order holder to that recognition and enforcement. The order holder can point to that statute insert. You can say, if you have it, you can point to it and say, federal law requires that my protective order be honored. And they're like, no, no, it wasn't. Levy County was like, no. This is precisely the type of rights creating language that courts have found sufficient to support Section 1983 enforcement. The statute does not merely encourage or suggest that the states honor protective orders. It mandates they do so, thereby creating an enforceable right individuals those orders protect. Again, it's mandatory. I like that, you know. Hey, Robert, thanks for the 10 there. The 8th District, owned as is just as corrupt as rest of the sus, most of the commissioners in Levy County. I live there. I should know. Oh, indeed. Man, I've seen some orders. What you have to do, though, is you have to go up the chain. And again, what they're telling you, too, is that if all of this stuff is valid, this is a two-way street. So just remember with all of that, if I were Hales, I would talk to a certain neighbor out there. See, me, this is kind of asshole. I would talk to the neighbors across the way that they like to talk about, the monsters, which apparently they're okay with being in league with monsters. So I don't give a fuck what they say about this person. I don't know anything about them either. I don't know what kind of a person they are, whether they're terrible or they, or what. I don't know. I would never take their word on it, but I would talk to that person, and maybe that person would like, to put up cameras that face these weirdos' home. Maybe they like to do that. Maybe they like to put a camera up too. Maybe they would not mind if someone else pays the bill for that camera and has access to it. I mean, hey, they said that's all good, right? That's all gravy. Again, I'm not saying anybody do that. I'm just saying I'm the kind of asshole that would really think about doing that. I mean, again, they're okay with that. They've been doing it for a while. So maybe, I call it the FATS cam. Now, they've been talking apparently about putting out a birdhouse cam and saying that they're going to watch birds. Why do the same thing with them? I'm just saying, they said it's okay, right? All right. They've been doing that for a while. So fuck them. Section 2265 directly mandates interstate enforcement of protective orders to safeguard individual domestic violence victims without conditioning compliance on federal funding or limiting federal involvement, distinguishing it from both spending clause legislation that operates contractually through voluntary state acceptance of funding conditions and the Parental Kidnapping Prevention Act that emphasizes jurisdictional standards while deterring substantive family law matters, or rather deferring, I said deferring substantive family law matters to state courts. What does that mean? Section 2265 fundamentally concerned with ensuring that individuals who've obtained protective orders can rely on those orders to protect them wherever they go, anywhere in the U.S. The statute does not establish a general framework for interstate jurisdictional cooperation or create a comprehensive system of managing court records across jurisdictions. Instead, it addresses specific concrete needs of the protective order holders to have their orders recognized and enforced when they cross state lines, whether fleeing an abuser, relocating, no matter what. Let's just say, no matter what they do, if I go to another state, I have the right to be protected. That's why that was created. This shows that individual focus is evident in the nature of the protective order themselves. Each protective order is issued to protect a specific individual from a specific threat. The stated purpose of 2265 was to, quote, close a major loophole by requiring that each state honor the protective orders issued by other states. By mandating full faith and credit for those orders, Congress addressed the individual safety needs of DV victims and other persons seeking protections, not abstract governmental or systemic interests. Again, it's not abstract. The language in it is cut and dry. The function of it is cut and dry. The reason for it is because they're not suggesting why this exists. They're telling why this exists. Aggregate focused statutes are in stark contrast to Section 2265's individual focus. Aggregate focused statutes serve primarily in accordance with federally imposed conditions to direct the federal government's distribution of public funds. And they talk about, again, what that is. Again, this is a distinction between This is not a suggestion. It's what all of this is saying. This is mandated. And it notes, although federal statutes have the potential to create 1983 enforceable rights, they do not do so as a matter of course. For spending clause legislation, in particular, we recognize that the typical remedy for state noncompliance with federally imposed conditions is not a private cause of action for noncompliance, but rather action by the federal government to terminate funds to the state. The spending clause, as outlined in, so they go through Article 1, Section 1, Clause 1 of the U.S. Constitution, grants Congress the authority to impose conditions on states in exchange for federal funding, provided these conditions are clear and voluntarily accepted in the states. The spending clause legislation is often described as contractual in nature, requiring states to knowingly and voluntarily accept the terms of federal funding. So again, it goes through that. I'm not going to read this part, okay? Again, you can read that in depth, and I would suggest you do. I'm just not going to bog down in the minutia of that. I'm reading the argument itself. So additionally, the 11th Circuit has emphasis that when interpreting statutes, courts should favor readings that avoid preemption of state sovereignty unless Congress' intent is unambiguous, particularly in the context of spending clause. So they talk about, again, with that, there's a point to all of this too, because Congress's power to impose obligations upon states under that clause, quote, rests on whether the state voluntarily and knowingly accepts the terms under which the federal funding is offered. And also such legislature is binding on states only insofar as it is unambiguous. This principle underscores the importance of clear congressional intent when imposing obligations on states under the spending clause. The legislative history and statutory framework of 2265 does not explicitly indicate that its requirements are tied to federal funding conditions. That is typical of spending clause. Instead, the statute primarily establishes the requirement of full faith and credit for protective orders issued again everywhere, let's just say. Section 2265 does not reference conditions tied to federal funding or suggest that compliance with its provision is a prerequisite. Again, what they're saying is, look, with 2265, with the protective orders, it's not saying that, compliance has to come with this prerequisite. Blah, blah, blah. Again, this is because 2265's focus is on the enforcement of protection orders and the jurisdictional authority of courts, including tribal courts, rather than on the allocation or conditional disbursement of federal funds. This is consistent with its purpose of ensuring that uniform recognition and enforcement of protective orders across jurisdictions, rather than incentivizing compliance through funding mechanisms. Again, they're saying some of this stuff out here, you have a funding mechanism, right? You opt into it. If you don't opt into this is required. So there's a difference, and it's establishing a groundwork for the argument for that. That's why they're talking about this. It's not an opt-in, this is mandatory. Therefore, based on statutory text, relevant case law, 2265 is not tied to federal funding conditions in the manner of typical spending clause legislation. Rather, 2265 creates a specific legal obligation that operates on case-by-case basis, protecting individual rights in individual cases. This individualized application demonstrates the Congress focused on protecting individual persons, not on achieving aggregate outcomes or systemic goals. Nevertheless, 2265 must be analyzed in light of the Supreme Court's reasoning in, again, your case law, in, quote, either its constitutional or statutory incarnations. The full faith and credit clause is a rule of decision for courts, not an implied federal cause of action. However, unlike statutes that explicitly confer a right on specified classes of persons, like 2265, the legislative history of the Parental Kidnapping Prevention Act that's the PKPA, provided unusually clear indication that Congress did not intend for federal courts to play the enforcement role. In sum, the context, language, history of the PKPA together made out a conclusive case against inferring a cause of action in federal court to determine which two conflicting state custody orders were valid. This is because legislative history of the PKPA demonstrates Congress's reluctance to create a federal cause of action or involve federal courts in the substantive custody decisions. Instead, Congress focused on establishing jurisdictional standards and ensuring that the state courts adhere to these jurisdictional standards. Federal court was not intended to resolve substantive custody disputes, but were limited to addressing jurisdictional conflicts under the PKPA. This limited federal role, they're talking about federal roles, how things were. But again, I think this is understandable. They're contrasting. Okay, so they're saying this versus this. All right, so with the PKPA, they're saying there was a limited role. They weren't trying to lay out all of this and say this is the function. Therefore, give me one brief second. I need to. I'm not even moving very far. I want to notice that there's a weird sound. I want to see something real fast. Give me just a second. I just got to check something. Give me a second. I'm coming right back. That's weird, man. I know y'all can hear me, so I'm coming right back. I heard something on the. I have a little buzzer on my stove that goes off if it's been left on, but also with the power flicks, it does that too. And I guess the power flick, but I was just making sure. I was like, surely, I didn't leave the stove on or something, but I had to check, if I hear that little boop, I was like, what is that? Anyway, sorry about that. Again, safety concern, but apparently we had a little power flicker today. So anyway, the conclusion is that in enacting the PKPA, Congress did not intend to involve federal courts in resolving state custody disputes, as doing so would entangle them in traditional state law matters. So again, they're contrasting these two. In contrast, the legislative history of 2265, it reflects that Congress's recognition of the need for federal intervention to address the inadequacies of state systems in dealing with DV. The provision ensures, what's crazy about this too, is the FATs especially sat down and they tried to argue that with protective orders, these aren't the same as DV protections. And they are very much it's the same thing. It boggled my mind because Hales said that the enforcement of this is just like DV. And they were like, no, it's not. Yes, it is. That's exactly. It blows my mind hearing people be so misinformed or they don't understand. Like, again, this isn't just an argument that applies to Jeremy Hales or to George. This is an argument that functionaries out there, people like Dan Owen, can tell you F you and not protect you. And do you want that? That's the question. Do you want that? Because for me, that's not what these people are voted in for. But the provision ensures that protective orders are enforceable across all state lines without requiring prior registration, thereby removing procedural barriers that could hinder enforcement. Congress explicitly acknowledged the interstate nature of DV and the need for federal jurisdictions to address these issues effectively. Now, whether the legislative history of PKPA emphasized limited federal involvement and deference to state courts in resolving child custody disputes, The legislative history of 2265 highlights Congress's proactive approach in addressing DV through federal intervention and removal of jurisdictional barriers to enforcement. So again, they wanted to be proactive. They weren't trying to sit on the sidelines, you know? Indeed. You know, this is the thing too. Okay. I think this brings up something. The flea market. Hales, you know, they claim that Hales, thank you, by the way, Jax, I appreciate the heck out of you too. But I think this brings up a good point. With the flea market, Hales knows exactly where these people are all the time. So, you know, with that, they say that, oh, he goes out of his way to harass. He's there every time we do anything. Well, if that were true, he'd be at every flea market, everything else, right? And he's not. He's not. But apparently, again, he could be. I mean, again, it's all gravy. It's all okay. So it's just crazy, isn't it? 2265 does not provide an alternative enforcement mechanism or prohibit Section 1983 actions, indicating that Congress has intended individuals to enforce their rights under 2265 through Section 1983 when states fail to honor protective orders. So the third factor in the 11th Circuit analysis considers whether the statute lacks an enforcement mechanism through which the aggrieved individual can obtain review. I like using that, aggrieved and aggressor. I like that language. You'll notice I use it a lot sometimes. You know, they're the aggressor or they're the aggrieved. 1983 is generally and presumptively available remedy for claimed violations of federal law, apart from exceptional cases in which Congress itself has made it clear, either by express words or by providing a comprehensive alternative enforcement scheme, that violation of the statute will not give rise to liability under Section 1983. So 2265, again, if anybody has confusion with this, just write down again what 2265 is, what 1983 is, and you can keep up with this argument pretty easily. Okay, and we determined that at the beginning. So 2265 does not contain an express prohibition on 1983 enforcement, nor does it establish a comprehensive alternative enforcement scheme that would be incompatible with individual enforcement of Section 1983. 2265 does not create an administrative review process, establish a federal agency with enforcement authority, or provide any other mechanism through which individuals can vindicate their rights when the state fails to honor them. The absence of that alternative enforcement mechanism strongly supports the conclusion that Congress intended individuals to be able to enforce their rights through under Section 2265 with Section 1983. So they're saying, look, Congress, there is no other way to go about this. So when you look at states not uphold, what happens when they don't uphold your protective order? When they don't give full faith and credit? Well, obviously, they don't have another alternative mechanism where you can go about bringing this up to court. So obviously, Congress intended that you would be able to go through Section 1983. You know, again, that seems like that would be very easy to understand. And yet, remember, 1983 is there. So you can file a civil lawsuit when someone acting under government authority violates your rights. And the courts, again, how else would you go about it? What else would you do otherwise? How else can you hold them accountable? There is no alternative mechanism that was established. So without Section 1983 enforcement, individuals whose protective orders are not honored would have no federal remedy for violations under the federal mandate, a result inconsistent with Congress's evident intent to protect vulnerable individuals. Obviously, they made it very clear, mandatory language. You have to do this. When you don't do it, obviously, this mechanism, that is the way they intended for enforcement to occur. So while courts generally avoid implying private rights of action when a statute provides an express enforcement mechanism, this principle does not apply to 1983, which serves as an express statutory remedy for violations of federal rights, and statutes like 2265 create enforceable federal rights under 1983 by mandating recognition and enforcement of protective orders across jurisdictions. I think that's pretty cut and dry. You understand. So in examining statutory structure, courts look for whether that structure provides a discernible enforcement mechanism. And if so, the court ought not imply a private right of action because the express provision of one method of enforcing a substantive rule suggests that Congress intended to preclude others. However, while this principle applies to implied rights of action, it does not apply to 1983 enforcement of statutory rights because 1983 is not an implied right of action. It is an express statutory remedy for violations of federal rights. The question is not whether Congress intended to protect private right of action with 2265, but whether 2265 creates a federal right that is enforced through the generally available remedy of 1983. That statute structure demonstrates that it creates such a right by mandating that protective orders receive full faith and credit and must be enforced by other jurisdictions. Congress created a legal entitlement for protective order holders, the right to have their orders recognized and enforced across state lines. This is precisely the type of individual right that 1983 was designed to protect. Makes sense. 2265 unambiguously, again, creates enforceable individual rights for protective order holders. If a federal statute's text and structure provides some indication that Congress may have intended to create individual rights, and some indication it may have not, that means Congress has not spoken with a requisite clear voice, and ambiguity precludes enforceable rights. However, 2265 has no such ambiguity. That's right. That is right. 2265's text and structure consistently points one direction toward the creation of individual rights and protective order holders. 2265 mandates full faith and credit for protective orders using mandatory language, focuses on the needs of individual protective order holders, and contains no alternative enforcement mechanisms. There is no competing indication that Congress intended merely to establish general policy goals merely to establish, give me a second there. My screen, when I rolled it, jumped. And it was like, wait a minute. It rolled all this sentence together. He's like, wait, that doesn't make sense. There's no competing indication that Congress intended merely to establish general policy goals or to benefit only governmental entities. That was so weird. When it rolled like that, it just blurred half of it. I was like, what is that? That doesn't make any sense. There, better. Now it does. Any suggestion that 2265 focuses on interstate jurisdictional cooperation or systemic coordination misses the fundamental point. The purpose of requiring such cooperation is to protect individual victims of DV and other threats. That means interstate cooperation serves the end, individual protection. And it is the protection of individuals that constitutes the state's core purpose and unmistakable focus. Appellants have valid protective orders issued in Ohio court after a hearing at which the restrained parties had notice and opportunity to be heard. The issuing Ohio court has jurisdiction over the parties and subject matter under Ohio law. This establishes that the protective orders meet the statutory requirements for full faith and credit. Since the appellants obtained the protective order from Ohio complying with Section 2265, Florida is obligated to give full faith and credit to the Ohio orders. Again, it talks about case law with that, providing that a protective order entered by North Dakota courts satisfies the provision of 2265 and was entitled to full faith and credit. That means that 2265 unambiguously, what people need to do, if they will not enforce this, what needs to happen here? is that Dan Owens' own words and all these freaking people's own words about they don't have to do this stuff. It should be plastered everywhere when they run for office. Billboards should come up talking about their own words because they always run on a platform that says that they are for victims. And yet their own words say that they don't give a fuck about victims. And I am tired of that. I am tired of seeing these agencies run on this idea that they're out there, that they're protecting victims when they don't. Instead, they victimize. If you have gone through the courts and you have established a protective order and people are still effing around with you and trying to, again, do harm, they have brought in other people to do harm, something should happen. Instead, places like Leavitt County should be shut down. I've seen this happen. I'm talking about their sheriff's department. She's shut down and replaced by another. They should fire every asshole there and they should replace them. They should replace all of these because they have, again, it's not just from this case. They have done this for years. They have been called out on a national stage because they don't give a fuck about victims. And it's the same people. I think we have created a predatory class of protected individuals out there that are just as bad as the people we're trying to be protected from. I mean, if they are not out there protecting you, then what do? They're protecting predators. That means that they themselves are predatory in nature. Fuck them. Replace them. If I have to protect myself, then why am I paying these people salaries? It's disgusting, man. So that means that 2265 unambiguously benefits individuals protected by protective orders and creates an enforceable right under 1983. This statute creates rights creating language focused on individual beneficiaries, addresses individuals rather than system-wide goals, and lacks any alternative enforcement mechanism that would preclude Section 1983 enforcement. Under the standards established by the Supreme Court and the 11th Circuit, 2265 satisfies all requirements for 1983 enforceability and supports a cause of action for individuals whose protective orders are not honored by other jurisdictions. That means 2265 unambiguously creates enforceable individual rights for protective order holders because its text and structure mandate full faith and credit for qualifying protective orders, employ rights-focused language directed at individual beneficiaries rather than systemic coordination, address individual needs of DV victims as the statute's core purpose, and provide no alternative enforcement mechanism that would preclude 1983 remedies, thereby satisfying all requirements for private enforceability when jurisdictions fail to honor valid protective orders issued by courts with proper jurisdiction after notice and opportunity to be heard. The court should reverse the district court's order, granting a motion to dismiss and remand further proceedings. 2, I think that is very cut and dry. What it's saying is, again, Congress meant for this to happen. They made it very clear that this should happen. If these assholes will not enforce it, that means that there is no other way to bring up violations, nothing else. If there's no other way to do that, then Section 1983 applies. That is the way that when your rights are violated, you go and you sue. And these people you should be able to sue them under that too. If they refuse to honor your protective order, then the district court erred in dismissing appellant's procedural due process claim by misapplying the legal standard, conflating substantive and procedural due process doctrines, and failing to accept well-pleaded factual allegations as true. Now, again, remember our plausibility standard we talked about. So they have to apply that controlling precedent. The appellants have stated a facially plausible claim for violation of procedural due process. Now, to establish a procedural due process claim under 1983, you got to have 3 elements. All right, remember these. These are important. 3 elements. A deprivation of constitutionally protected liberty or property interest. You have to have state action and constitutionally inadequate process. The complaint must be evaluated by accepting all well-pleaded factual allegations as true and drawing all reasonable inferences in the appellant's favor. Again, they're supposed to look at everything like, hey, before we dismiss, you got to look at it look at it as if everything is true and look at it in the light most favorable to the person bringing it. If you look at that and you say, hey, they've got a case, then it needs to go forward. Unfortunately, that way too often doesn't happen, especially when it comes to these people. They have created a protected class, again, that we never meant to create. We never meant to protect. We never meant to have this protected class protected from us if they violate our rights. That was never the intention of any law. So the Due Process Clause protects individuals from arbitrary government action by safeguarding fundamental liberty interests, such as bodily integrity and freedom from harm, originating either directly from the Constitution or from state law, and provides heightened protections against governmental interference with these rights. So the 14th Amendment Due Process Clause provides that no state shall deprive any person life, liberty, or property without due process under law. 14th Amendment liberty interests may originate either from the Due Process Clause or from the state itself. So the Due Process Clause protects individuals against arbitrary and unreasonable exercise of governmental power. Now, appellant allege a protected liberty interest in their personal security, bodily integrity, and freedom from private violence. Specifically, appellants allege they are protected persons under 2 valid order of protections issued by the state of Ohio designed to ensure their safety and security. These protective orders were issued after a hearing on October the 10th, 2023, in which the persons against whom the order were issued had reasonable notice and opportunity to be heard. The liberty interest appellants assert is not merely a state-created right subject only to state law procedures. Rather, it's a fundamental liberty, an interest in bodily integrity and freedom from harm that the Due Process Clause itself protects. The 14th Amendment's Due Process Clause includes a substantive component that provides heightened protection against government interference with certain fundamental rights and liberty interests. Now, 2, the Ohio Protective Order and federal law both recognize and provide a procedural framework to protect individuals' pre-existing constitutional liberty interests and personal security, with federal law ensuring these protections are upheld across state lines. The Ohio Protective Order do not create the liberty interest. Rather, they recognize and provide a procedural framework for protecting the pre-existing constitutional liberty interest in personal security. The issuing court had jurisdiction over the parties and subject matter under Ohio law, and the orders were issued after a hearing with notice and opportunity to be heard. These judicially issued orders represent a formal recognition by a court of competent jurisdiction that appellant's liberty, interest, and safety require protection from specific individuals. These orders are designed to protect individual safety and liberty interests by restraining specific acts of harassment and intimidation. Exactly. This is what it's for. It protects your liberty interest. It protects your safety. It protects your liberty by restraining this stuff, which is supposed to be upheld by law enforcement. That's why they exist. Federal law reinforces this framework through Section 2265, which mandates the protective orders issued by one state shall be afforded full faith and credit and enforced by court and law enforcement personnel of the other state. This federal statutory mandate recognizes the importance of protecting individual liberty, interest, in safety across state lines and creating a procedural framework for ensuring that protection. Now, the deprivation of state-created rights can still violate procedural due process if constitutionally adequate procedures are not followed, as illustrated by the appellant's claim regarding deprivation of liberty, interest, in safety that after judicial protection orders were issued. So the district court order does not explicitly address whether appellants alleged a cognizable, my mouth cognizable. I got it right there. It just doesn't want to come out well today. Liberty interest. Instead, I think it's my southern. It doesn't like certain words sometimes. The court focused on whether appellants stated a substantive due process claim and concluded that they had not alleged facts that supported such a claim. This analysis fundamentally misapprehends the nature of appellant's due process claim. As the 11th Circuit has explained, deprivation of state-created rights that do not give rise to a claim for violation of substantive due process may nonetheless give rise to a claim for violation of procedural due process. So they talk about that again. You can read through this at leisure. Here, the appellants do not allege that the state had an affirmative duty to protect them from private violence or that the state's failure to act violated substantive due process. Rather, they allege that once valid judicial protective orders were in place recognizing the liberty interest in safety, Owens deprived them of that interest without constitutionally adequate process. This is quintessentially a procedural due process claim. Interesting, yeah? So procedural due process serves as the essential constitutional safeguard that protects individuals from arbitrary government action by guaranteeing notice and a meaningful opportunity to be heard before any deprivation occurs, whereas substantive due process merely prohibits certain governmental action outright without offering the procedural protection that ensures fairness, transparency, and the opportunity to contest erroneous deprivations before they cause irreparable harm. That is a hell of a title, is it not? So procedural due process and substantive due process are distinct constitutional protections. Procedural due process affords notice of a possible government deprivation and a meaningful opportunity to contest it, usually before it is imposed. Again, goes through all of that, again, statement. Read it at your leisure. By contrast, substantive due process bars certain governmental actions regardless of the fairness of the procedures used to implement them. A violation of substantive due process is complete when it occurs and no amount of process can justify its infringement. Quote, unlike substantive due process violation, procedural due process violations do not complete, quote, unless and until the state refuses to provide due process, unquote. So the district court erroneously applied substantive due process standards to what was fundamentally a procedural due process claim, where the proper inquiry is whether a state actor deprived individuals of a protected liberty interest without constitutionally adequate procedural safeguards before that deprivation occurred. So they're like, hey, this was an error. The way you looked at it was an error. We need you to look at it from a different light. We need you to look at it again because you created an error there. And that's what appeals are for. The district court's analysis demonstrates a fundamental confusion between these distinct doctrines. The court cited, again, you have case law for the proposition that it's that in the substantive due process analysis, it is generally the state's affirmative action of restraining liberty that gives rise to substantive due process, not its failure to act to protect citizens from harm. This district court also cited Another case here regarding when conduct by a government actor rises to the level of substantive due process violation. These authorities address substantive due process and the state-created danger doctrine, doctrines that govern when the state has an affirmative constitutional duty to protect individuals from private harm. But the appellates do not allege a failure to protect claim or assert that the state had an affirmative duty to shield them from private violence. Instead, they are alleging that Dan Owen, acting under the color of state law, deprived them of recognized liberty interests without providing constitutionally adequate process. You understand? They're saying, you looked at this wrong, dudes. You know, when you looked at it, when you looked at the violation, you're looking at the violation under the wrong light. We're going to go for a few more pages, you know. We'll go for a few more pages because we're never going to get through 70 pages tonight. These are 70-page documents. It is not a partial document, okay? Just to make that clear, too. This is like not 70 pages with this or that, but yeah, in totality. Yes, they did say that, by the way, Winby. They did. They said in the protective order hearing, you had these morons get up there, and the undersheriff of Levy County said that they looked at the circumstances, the totality, in totality. Which makes no sense. Again, you don't look at the overall issue. You look, did this person violate that? That's the totality of it. It's not to say, again, they apparently wanted to get up there and argue, Jeremy Hales is doing this or talking about it for clicks. Well, that's not, first of all, that's not their purview. It has already been given. So their enforcement is, again, if this person violates, I don't give a fuck why they did it. The Ohio court disagreed with that. They said that it was done for a different reason. What that tells me is that all these jackasses got together, like the Dan Owens, the undersheriff, all these cops. They sat around, and you can tell it from some of the FOIA requested documents. They sat around and they decided to create this narrative in which a person can never be protected. Why? Because they go back to this beginning statement. They're saying that essentially all of this is rooted in 4 clicks. Therefore, anything, you know, with this tree, when it grows out, any branch, any fruit, anything that comes from it, it doesn't matter. That's not inherently wrong. That's biased as fuck. And again, it allows somebody to be harmed. You know what Levy County, you know what hell would be created if Levy County allowed Jeremy Hales or George or somebody with them to be harmed by some piece of shit like John Cook, like Preston, or like somebody that's been listening to the Fats and more, because these people have been calling for violence. Ray 100% called for violence. When he was talking about counting ammo and doing all of that shit, that is a call for violence. They've made it clear, too, that harassing is okay. They've also gone beyond that and said that these people pose a danger to child. They love to throw that in there. And that will motivate people to do terrible things to you. And they've been trying to do that for a while now. Again, if it were aimed at some other person out there, they would totally agree that this was monstrous. But because it doesn't fit their narrative. That's the danger of all of this. They've decided that, again, this thing that Dan Owen and Levy County have done, it could be applied to other people. And if it were applied to other people, you think about that. They don't care how it's applied here, but it's setting the standard where it can be applied to other people too. It may have been applied this way. and they absolutely don't care. Kevin also, thanks for the 10. These idiots are the reason I won't move to Florida when I retire. Yeah, you know what? I had thought about Florida at one time, and I'm like, you know what? It's not worth it. It's absolutely not worth it. And it's sad, you know? That is sad. And I thought about, man, you know, for myself, I would love to go out and to do my thing, you know, to yeah, again, somebody wrote and noted this is it again, very, very understandably. Out-of-state protective orders are enforceable in Florida if they meet federal requirements, including validity, proper notice, opportunity to be heard. While they do not need to be registered for police to enforce them, registering the order in Florida can help, especially for provisions involving child custody. Enforceability, valid protective orders from other states, again, full faith and credit. They are enforceable in Florida just as if they were issued by a Florida court, according to VAWA, the Violence Against Women Act. They noted my belief is if an order is competently drawn up, it must be enforced. Yes, I 100% agree with that. That's how it's supposed to be. And again, if the order was against Hales and this happened, these people would be 100%. They would be pounding the gong and talking about how these people were monsters. But instead, so I'm going to read. Actually, you know what? I'm going to read to it right here, and we'll stop there for today. I think that's a good place. Let me give you, by the way, while I'm thinking about it, give me 1 second. I'm going to drop you a folder link for Dropbox, and this will allow you to grab both of them. I usually would just give you a link to the, I'm not going to put it on, I'll put it on Facebook too. I will not put it on YouTube because YouTube has been very weird outside of like, you know, you can ask for like a Venmo or Cash App or whatever, but they've been very weird about outside links lately. So I'm not going to post it there, but I will post it also on Facebook. So I'm going to put it right here. I'm going to give you all a chance to download. This is through my Dropbox. You should be able to access that, pick it up. Give me 1 second here. I'm linking it while we go through. But this will give you a chance to pick up both of these without paying for them. You know, you should not have to, again, you should be able to easily pick that up. So you may have to download the app to pick it up or whatever, but that is the link to both. You can't just mail it out there. There has to be a way to drop it to you. And these are big files. So again, I dropped it out there for you. And that'll allow you to pick it up. Give me a second. I'm going to pin it for a few minutes. I'm going to talk for a few minutes also. And then we will hit Super Chats. We'll go from there. What time tomorrow? We're probably going to go it will be 3 p.m. my time. You know, so I've been going about 4 hours gives me time to go through whatever. I really want to hit that John Cook stuff. You know, I very much do want to hit that. This is an interesting argument. Again, this goes to the point. When you look at this, what is the point of doing it? It's a question of whether, number one, protective orders. What is the point in having a protective order? A rule, rather, you know, like when we're talking about 2265, what was the intent behind Congress discussing that? And the intent, obviously, it's unambiguous. They're not giving guiding principles. They're not saying, well, you know what? Maybe you should enforce it this way. Maybe you should do it that way. No. It's telling you 100% it is protective order. You need to enforce this. It's unambiguous, right? It guides you. Full faith and credit is not ambiguous language. It's not, again, it's not them going, because some things, when when the Fed steps down, they create guidance. You know, in the guidance, there's suggestions because they don't want to trample on state rights. That's understandable. That's why, again, they brought up custody disputes, because custody disputes, when you get into that stuff, you're getting into state courts, and you're getting into something that, again, if there was a federal guideline that came in from state to state, that might differ. With protective orders, however, this is talking about once they have been established, once they've been conferred on a person, then you have to treat them as if they were given to you by whatever state you're in. So again, even if Ohio gives it and you're in Florida, they have to treat it like it's given in Florida. Makes sense, right? Now, what's supposed to happen if they don't do that? Well, that's why the other arguments come in. This is not guidance as in, if you don't, then the Fed's going to withhold funding, you know, or other things like that's pumped up. Again, there are some things that you get federal dollars if you do it. And if there's a problem, then they'll pull funding. Well, this isn't like that. This is something inherently different. That's what you're talking about there. The only way that you can address this, they didn't give any other method, is through 1983 claims. Just like the way that you take police to task, government agencies to task, etc. There is no other method of doing that. So that's what they're saying. And when they're looking at it, they're saying, look, the courts here, you're trying to look at it one specific way. You're trying to look at it as if we were arguing X, but we're actually arguing Y. They were talking about substantive due process versus procedural. That's why that whole framing, that whole mechanism they discussed there, that's why they brought all of that up. Because they were like, look, you know, when this was done, the argument, I'm going to read this here. When they look at it, the authorities address substantive due process and state-created danger doctrine that governs when the state has affirmative constitutional duty to protect individuals from private harm. But the appellants, they're not alleging a failure to protect claim or asserting that the state had an affirmative duty to shield them from private violence. They're not saying that. What they're saying is that Dan Owens, acting under the color of state law, when he did this, he deprived them of recognized liberty interests without providing constitutionally adequate process. He denied them due process. See, that's the argument with it. Saying you looked at it wrong. Now, will this work? Who knows? These kind of things are long shots. Holding the state accountable is difficult, but it needs to be done. It is not done enough. Why? Because it costs. That's one of the things, first of all. Now, how can you help with that? Obviously, they have, there has been funding to help, but even beyond that, watching videos, allowing a video to play when you walk away or something, say you leave your home, if you have a desktop or whatever, just let it play a playlist of these videos, let it go through those like that. That matters. That's a big deal. But I mean, this is terrible. Yeah, like Roy, I hate to say it, but if Jeremy or George had to use legal force to defend themselves against these people, yeah, the Levy County sheriffs would charge them. I believe so. I do. So that's the kicker too. Like, how do you protect yourself in this situation? Because I don't believe Levy County has given them a method where they can. And that's scary. It's almost like they dare them, to defend themselves. And like I said, that's a frightening endeavor. I think they would charge you if you tried to. So, again, they've been put in this horrible situation, and I hate it for them. It's one of the reasons that I try to catalog everything, because I am afraid at one time that something awful is going to come up. I mean, we've already seen Cook threaten to use pew-pews multiple times. We've seen these kind of threats. We've seen Lynette Preston say, this is how he's reactive, So in that, you have to ask again, what do you do if? And what you do is, again, you document everything. You document how these people have made threat after threat. And like I said, this is a terrible conversation that we're forced to have, because these people are very clear about being a danger. And again, I think that's frightening. That's frightening for anybody. But it's definitely frightening. These folks, again, they have talked about it, because what do? Do you shut down all your business? Do you go live under a rock somewhere? You can't do that. A lot of lives depend on them. But they have, I mean, the antis have been effective in harming business. They have been effective in driving people away. A lot of people are afraid because they have taken on multi-prong approach. They have threatened physical harm to people. They will do it under sock accounts. Some of these people, man, when people tell you you need to sleep with a Glock under your pillow, shit like that, that's a threat. That is straight up a threat. And a lot of people will walk with that. They try to threaten you by saying that they will try to tangle your life up forever in courts. And like I said, it works with people. You think about people who've covered this type of stuff, and they moved away. Why did they move away? It's not because of the claims that were there. It's because of the nature of the people. Because despite this, sometimes, one of the things when we cover like a Hollywood case or something, one of the pros to that is they can only go so far with their behavior. They're noted by everyone out there. Everyone can see their behavior. They may try to rip and roar and, threaten PR, and even in some cases even try to take you to court. But the physical threats, that kind of stuff, you don't typically see that. In this case, you have seen it, and you've seen it with people out there that, they're absolute pieces of shit. These people, some of them are awful human beings. So when you're talking about it, I think, like with this, will this work? It's stacked against you from go. I never want to say no, because, again, they managed to take a judge to task, and that is almost impossible to see. You never see a judge taken to task for anything that they do. So getting a judge removed from something, I mean, like I said, that to me, that's insane. Like, they managed to do the impossible already. So I hate to say never, but it is definitely an uphill battle. Now, I think that they have a good argument, but again, that assumes that the courts want to hear it. And these courts, whether it's a lack of interest, a lack of knowledge, or worse, again, you should go and look at that video that's on. Again, it's a lackluster video where they have you get to listen to the appellate court, and it is frustrating. That video, it pissed me off. Listen to it again. It's not somebody giving their opinion on something. It's the court speaking, and through it, they throw away quite a few protections. It's just, like I said, it is very frustrating. A lot of this stuff, though, I think is eye-opening for people out there. And remember, a lot of these folks are they're elected officials. They may get lengthy times in office, but you can vote them out too. You can expose them. They all have their weaknesses in that. As far as the idiots, though, the antis, like I said, if the courts deem that everything they've done is not a problem, well, then they need to quit whining about people freaking talking about interviewing their neighbors. Again, we've gone to, I think this is funny. We've gone from having these people say that if you drive down the street, that's somehow a terrible thing when Hales does it too. How can you say that something terrible is being done if I drive down my own street, with the fats? So, it's funny because everything that they've claimed, everything that they've tried to weaponize, they either use it, it doesn't apply to them, or they don't want it done to them. Again, like Ray is so convinced that J-Hip and Clark Stark are stalking him. It's wild. If you've not listened to any of that, you should. It is wild stuff. But he's so convinced that all of this is happening. But they've applauded the idea of people stalking Jeremy Hales, going to where he lives, and again, while he has protector, they've applauded that. So I'm not by any way. I will, again, making it very clear, none of you should ever involve yourself. Don't contact these people. If they post publicly or something, you have the right to comment on public posts. I can't tell you can't, but interacting with them, it doesn't benefit you at all. But as far as Hales is concerned, again, if the courts fail, then let's look at these super chats here. Fallen Hero kicks that off. Thank you, Fallen Hero. First of all, thank you. And second of all, thank you for being here, too. Thank you for the gifted membership. Thank you, my friend. Thank you for always being here, brother. Puzzler, thanks for 5. Let's all hide, stick up on Doug, and scare him like Pop does. Oh, Laura, she's been doing that. She's done that a lot. Man, she's worn out today. She's been running, ripping, and roaring all day long. I've had her outside running around and doing stuff. And she finally, she goes from when she wakes up to when she crashes out. And she finally crashed out. But she's hilarious. When she runs out, it's like watching batteries drain, She'll go from woo to just crash. It's really funny. But yeah, she's been doing that. We've been taking care of mice, man. This winter, would not believe how many mice we had come in. We got all this area around us, so it does attract mice. But Lord, this year has been insane. We put out havoc, in the garages and stuff, which is how I hate using poison, but Lord, I put out enough traps and stuff, and I'm like, man, after so many mice, it's just like, no. Before I forget to, let's see. I'm putting this on. Here's the Dan Owen appeal docs. I'm posting this on Facebook. Okay. Again, I saw a bunch of people that were talking about buying them, and some of these lengthy ones, they cost a lot. All right. So we will usually get a document. I know if a person is going to go get it first, then they're getting it, but we don't need anyone to get them. Okay. If you get it, then send it. It saves us money and time too. That's fine. But if we get something beforehand, I don't want you to have to spend money, because some of these documents become, I mean, they're really expensive, sometimes. And the cost out of this stuff, it's one of the things, like with the Depp case, God, you were talking thousands and thousands of dollars. Now, you had certain people that will pull up a lot of documents, but even with that, man, you talk about significant cost. So here's the Dan Owen appeal docs versus Jeremy Hales. No. I hate the way this says, in Jeremy Hales v. Dan Owen. I don't like the way that sounded before. Sorry. Just sounded bad. But I posted both of them. I posted one of them, again, is a giant document that is an appendix. It's document. It's an 85. I did not edit anything in it. Okay. So if you post anything, there may be items in there that you need to redact. But if you want to catch them on this case, a lot of the stuff in there is good. Really, again, if you want to learn about what these people think about your rights, though, you need to look at Dan Owens' argument. It's so frustrating. It makes me so freaking mad. And it's in there. It's in the appendix. It's God, what is it? I can't remember which item it is. I think it's pretty far down the list of everything. But if you look in it again, the appendix has all of the items. So there should be, I see a bunch of you, I can see when you access it, by the way. So it's all good. I don't keep records on that or anything, just to know. I just have it pulled up and I can see a bunch of people accessing it. I can see your initials. I don't have anything that tracks. That's one thing I will note with you too. Some of these assholes out there, they will try to track you when you do stuff. So anytime like an anti says they're going to put up something, if they put it up through like a Dropbox or something, you be very careful with it. They may be trying to track. That's what Lips bragged about, tracking emails and stuff. For me, I don't utilize anything like that. I can just, like I said, I can see when people access because they pop up as people that are given the ability. Anybody that has that specific folder, if you've accessed it. I'm also noting this, it will be up for a while. So you don't have to worry about me like putting it up and just pulling it back down later on. All right. So I think that's also worth noting. Sometimes people are like, well, I put that up, I'm going to put it up for like an hour or so. No, it's only for, it's for that entire time. So anyway, let's continue. Rickles, thank you for the gifted membership there. Thank you also, Rickles. I appreciate you. And I love that freaking avatar. I love your statements about it. It's funny. Tracy, thank you for the 5 gifted memberships. Thank you for that too, Tracy. Very much appreciate that. Appreciate you too, as always. Thank you. Yeah, I saw by the way, thanks, Max Lab. Yeah, I saw that post. Like I said, I will bring it up. She's saying that somebody was on their cameras outside of their residence, taking pictures, and they are in front of the fence. It looks like they stepped across. Now, I'm gonna say 2 statements with this. First of all, nobody should. If you're on the road, legally, can you do that? Yeah, but again, just what's weird about this, though? All right, if they don't want people to come there, they need to remove the blessing box. That asks people to come there. It tells people that you are allowed to come there. If they take pictures with it or whatever, or they take pictures with the property, photographing, you're asking them to. You remove it, you put up no trespassing, whatever. But I would again state that nobody needs to make contact with anyone, to make it very clear there. I don't know, but they posted pictures. First, I don't know who they are. Like I said, until I see any proof of who or what, I guess we'll probably find out they put their license plate up too. But again, we'll talk about that tomorrow, though. We'll talk about the post too. But yeah, thank you. Robin, thank you, Robin. Appreciate that. Seeing there. Caffeine money. Indeed. You know, it's funny. I've been drinking a little bit of caffeine for live streams because live streams have taken, you know, we've been burning the candle at both ends lately. And it's good. I'm glad to be back. You know, I'm feeling better and better. Like I said, I want to do longer form video, but it'll take me a minute to get to that. But still, I'm feeling better. I've been doing a lot more and I like it. And thank you. I've been burning a little caffeine, but I've been trying to avoid doing a lot of it too. I'll see Wombat. Thank you for that giant super sticker, my friend. Appreciate you very much. You know, I'll see Wombat. I appreciate the fact that off of your name, I got to bring up what a wombat is to my kids. I thought that was a lot of fun. Considering how much trouble Jeremy and George had with getting the order recognized and filing, yes, it's crap. All of this stuff with the protective order is nuts. I agree with y'all. Like just getting to the point, then they've had to fight the system to get them to enforce it. Like all of this, I'll tell you though, like for real, getting courts to enforce they don't want to enforce your protective order as it is. Like that's the reality. If you have a terrible situation in which you have to get a protective order, it's awful to begin with. You know what? This is beautiful. One of the ways, like, you know, a certain idiot said they were going to have someone set out here and watch my home or anything. So my neighbors and I get along very well. And I told my neighbors who have a lot of kids and stuff that, you know, somebody noted that and they were like, you know, really, you know, they have like a bunch of teens and stuff. They take it as a challenge, you know, as a fuck you challenge. So I'm going to go make that very clear to them. Like, if you find these people, if you find somebody spying out there, you record them. You know, I've got to have like legit proof they're watching the home or anything. You get me their license plate. You give me footage of them. I'll pay you $50. You know, I like it. But my neighbors, though, beside me are so nice. One of their kids is he's into wrestling. You know, he's a wrestler, and I shouldn't say into wrestling. He's a wrestler, and he's done very well in the state. I believe he's in the top 20 out of the entire state. You know, they travel everywhere and stuff, but they've been trying to fundraise, you know, to get travel money. You know, they make them go out and sell stuff. So I gave them a little bit of money, you know, like $100 or so, you know, for it, which they were like, oh my God, you know, but I told them if they have trouble getting that, because for them to travel for the whole year is like $2,000, you know, which again is a lot of money. But at the same time, I was like, man, you all go out, you raise whatever, and then if you don't find enough, let me know and I'll put up something. I'll put up a GoFundMe. I mean, it'd be like $1,000 or something. These kids to go out and live this dream, man. Hell yeah. Top 20 athlete. And you have to beg for money. It's crazy, isn't it? But yeah, those same people, the beautiful thing about it is like these people are out here stalking. Like, I don't know how you and your neighbors are, but I live out in, you know, this is a more compacted area than we used to live in. I have neighbors that are here. I could walk over and talk to them. You know, used to, we couldn't do that, but they're good people. And they also wouldn't take kindly to some assholes sitting out and stalking their property. So it'd be very interesting. By the way, I still want to point out that all that bluster and talk, I told the fucker to sue me. I've posted about it on fucking Twitter. I'm going to continue. I'm going to make a long form video about being threatened with PIs, and I'm going to talk about the whole thing. And It's funny because I still haven't seen it, and I kind of want it. Like I said, it's about a $30,000 lawsuit, which I'm sure that I can pick up the money for. But I kind of want that lawsuit because that person, they think that all the terrible shit that they themselves have tried to expose. Now, apparently, according to the antis, by the way, we'll talk about all that tomorrow too, but that's just all nuts. Rogue Pirate, thank you for the gifted membership. Appreciate you, Rogue Pirate, by the way. I love that. I love seeing the pirate arg come up too. What's up, Amy? Thank you for that membership. It's beautiful to see you always too. But thank you for your membership. Thank you. Welcome. Thank you for the membership. Welcome to Thugs. Thank you for letting me say that too. Appreciate that. This is that statement. So thanks for the 5 there. When this appeal fails, are you guys going to start whining about the potted plant on the 11th Circuit of the potted plants, or the evil Levy County's reach is unlimited? I just like I said, they complained terribly about Levy County and how shitty and horrible Levy County was until they started saying that they themselves were plotting with Levy County. Then suddenly Levy County is the greatest thing since sliced bread. You know, like I said, if you want to reach down and lick that boot, if that's your thing, then I guess that's your thing. But for myself, no, I have a real problem. First of all, I don't like authority, period. You will notice that, you want to admit. I am not, when I talk about this stuff too, when we talk about policing, I hope people out there recognize that we're not talking about individual police most of the time. We're talking about the apparatus policing and how terrible it is and how awful some places they have like a chokehold on. Are there decent police out there? Sure. You know, but there are monstrous systemic issues, and that creates problems. I had my own problem, you know, in being a victim in a crime, and you know, having police try to cause me problems myself. I've seen that system, and don't appreciate it. It's a nasty thing to uphold. So, you know, if you can't see the problems in this, I don't know what to tell you. If you want to pretend that having a protective order and having people violate it and recruiting other people is okay, then just put your name and address out there. And I'm sure once the first person started showing up and recording your home and recording all of your movements and stuff, I think you would have a real problem with that. And then if somebody started popping up on your property saying the next time they came there, you know, they would bring something that would go boom, I think you'd have a problem with that too. I think a lot of these people are all talk because they know that this would be a real issue if it happened to them. But they don't give a fuck because it didn't happen to them. They're pro-stalking as long as it goes to someone else. It's craziness. Thank you, Here and After, by the way. Thanks for the 4 months. Thanks for bringing the documents. We appreciate it. Well, hey, thank you for being here. Appreciate that for sure. William, thanks for 5 again. Of course, they would enjoy the boot on the throat. I liked this. We expect anything less of bootlickers. And these, again, to clarify, these people really are bootlickers. They are. They made it clear. They are fetishes. So they really are bootlickers. Like it is an actual thing. So I find that funny when we're talking about, hey, do these people enjoy bootlicking? Yes, they actually do. They very much do. So is it a large step from bootlicking individuals to bootlicking authority? No, they enjoyed it. Again, that whole leather obsession, like Tori, she's not out there just making leather bags and shit. She's a fetishist. They are freaking... They have articles, which creepy articles, talking about how they've also introduced their kids to our kid to the messed up shit too. I posted part of that article. Oh, so gross. But yeah, they are bootlickers, so it is funny. Jack's mom, thanks for the 5 there. Send Tug to Florida fun or candy fun, indeed. I think at one time I would like to go down and check out all of the Hale set up. I'd love to see this stuff set up across the street and everything. These people would have an absolute flip out. If again, though, I don't know why they would, because Lynette Preston tried to recruit me to help her out. So you couldn't say it's harassment. I wouldn't, unlike these people, I wouldn't go over. Would I take pictures of the Great Wall of Otter Creek? Oh yeah, for sure. Would I go on their property? No, but they can't complain if I took pictures from the street, could they? Because they do that to everything over on the other side of the streets. They use that as a method to say it's. And they've also had paint chips talking about going there and talking about harassing Hale. Like he put up a conversation with John Cook at one time discussing that. So again, it's not like they haven't done all of that. It's not like they haven't done it. And again, if it's okay, then it's all okay. No complaints. But yeah, thank you. S. John, thanks for the 10. Go to Florida fun. Let the petty begin. Indeed. Indeed. Thank you, S. John, too. Much appreciate you. Andre, thanks again for the 5 there. All the shit happening, Jeremy and George, affects everyone that they help. I thought this was a good point. Kids at Christmas, to helping the homeless with clothes. Yes. Every good thing that they've done where they've had to pull back, it's all affected. All those people. How much money could have gone into helping instead, Just crazy, isn't it? Miss Eric, thanks for the 5 there. Levy County, yes, indeed. It's the reason so many victims don't come forward. The fear that people we pay to protect us won't is a real problem. Yeah, there's 2 issues in this. You're looking at the ineffective policing after it's been promised, which is crazy. And on top of it, you are also looking at false accusers. You were looking at like Lynette Preston that, puts up false accusations and shit, and the state mechanism backs them. Again, I think that's another issue. That's a big one we've talked about. So yeah, Mama Bear, thanks for the 7 months. Thanks for all you do. Love to you and the girls. Thank you from Canada. It's mind blowing. Yeah. Law enforcement actually causes us to lose respect and faith in them. Yes. It's a real problem. It is a real problem. And thank you. Again, these are outside the U.S. people looking into. It's crazy. Robert, again, thank you. 8th District Court. Owen is just as corrupt as Russ the Sus and about the commissioners in Levy County. I live here. I should know. That's nuts. I'm curious about how Levy County, people that live there, again, I'm always curious about if you've had interactions with the police out in Levy County, or you've had interactions with the police, especially in that specific, like Otter Creek. If you have footage of your interaction, oh my Lord, you ever got a problem and you want to note it, and it's something worth noting? Hell, right. We'll definitely bring it up, and we will shield your identity if we need to. Jack Small, thanks for I'd show up at the flea market every week. And yeah, that's exactly the whole point. Like Jeremy Hales could have done that. He could have. They've accused him of doing all of this stuff. Like I said before, he could have been doing that, but he didn't. He drew a line. These people, they don't. Again, yeah, Winby, in totality. That's right. It's so crazy, isn't it? Kevin, thanks for the 10. These idiots are the reason I won't move to Florida when I retire. Amen. Amen. Yep. Law enforcement plus. I mean, look at like the Fats in the villages. The villages, I always thought of the villages outside as a retirement community. Then I find out that absolute nasty, fetishy pieces of shit like this, they reside in Florida. They reside in there where they're trying to ride around looking like, again, looking like they're trying to deliver the one ring, but instead they're delivering the one loofah to people that, explains why they have a high STD rate. Gross. All gross. Yeah, thank you for that $5 super sticker. Thank you for the super stickers. I always appreciate that. I love showing the kids, so I always clip them and show them. They love those. Allie, thanks for the 5. Isn't a key part of Owens' role to prosecute those break and protection orders? So he's responsible to ensure they are respected and upheld. Yes, he's supposed to. And to say that if he tells you not to enforce it ahead of time, you think about how crazy that is. If he's told police before any issue has been investigated at all that he would caution them against doing that, think about how irresponsible, and that's a way to get someone killed. That's nuts. Yeah, you're 100%. Pickled Tank, thanks for the 5. Jeremy should get a billboard that says, I wonder what would happen if Dan Owens' wife needed a protective order. Yeah, now I would always, I would say that you have to be very careful in bringing up any personnel like that, because you see, like with family, it's a valid point, but you see the way that like Ray twisted it, right? I'm the victim now. You remember the whole Ray thing? Oh, somebody said, oh, what if this happened to your daughter? I'm the victim. Well, that's what Dan Owen would do, but Dan Owen would do it with the entire, the ability to bring down Levy County, and I bet you he would prosecute then. I bet you that asshole would be in there saying that Hales had threatened and everything else. But yeah, I see your point. I actually think what somebody should do is they should take his own words from this, his own defense, and give it to every fucking voter in that area and tell them this right here is what they think of you if you're in trouble. They think that they can persecute, not protect you. Yeah. Pickled Tink, thanks for the 5. Doug, they're not wrestlers this far south. They're wrestlers. Indeed. I always think with wrestling, though, I always think when people bring that up, they're talking about, like televised wrestling. Wrestling is always like a WWE or whatever, WWF, whatever it is now. But, I was proud of the kid. Like I said, I thought they're good. These people, when I moved here, when I first moved here, this house, this area had belonged to one family essentially, and they had branched out. They built in, and it grew from there. But this whole block or portion had belonged to this one family unit. So when I first moved in, you could have well been outside or anything, but instead, these folks they had their kids come over, and they invited the girls to come outside and like jump on the trampoline and play and goof off, which was very nice of them. And from there, anytime we've had 2 small trees fall between the property, and people, they can be assholes about that if they want, but we've always taken care. Again, like I've paid for one of them to get chopped up. And the other one, they just chopped up themselves, So I thought, like I said, we've never had any problem. If there's an issue, we've never had any, issue, quote unquote. But if there's ever anything that's come up, we've always handled it. I like them. I think they're good people. Jack's mom, the Dropbox is empty. What am I doing wrong? I know, I can see it. I can open the link. Like I can click it. There's 2 files that should come up in the Dropbox when you click it. So I'm clicking it. Yeah, I'm clicking that link. I'm clicking it straight from the chat itself. Give me a second. It asks me if when I click it, because I'm on my phone, it's called Appeal Hales Share. That's what I called it. Was shared with you. It asks, do you need to get the app, or it says have the app, open folder. So when I click the open folder, there's 2 documents that I'm staring at. You should be able to access them, because that's my thing. Do you have Dropbox and everything set up? I can't mail them because they're so big, or I would mail them to people if you had a problem. But I can't mail them, unfortunately. They're just too large to mail. I'm sure, I don't know. I might be able to. I might be able to Google drop them if somebody has a problem. You know, I'll see. I'll see Jack's mom. Write me. Okay. Travis was a man. Thanks for the 2 there. Guys, young brother, been detoxing from birthday. Torres. Yeah, I'm sure, dude. You going out again. You're crazy in the best way possible. I mean, you know what I mean? You're crazy there going out and doing this stuff. Ma'am, I can't believe you like, it's just wild, dude. I actually like you, Travis. I think you and I would get along in real life. I think we would. I think we have a good laugh at shit. You know, you like to live life, you know, and have fun. Your stories have got to be fun. I've got some crazy ones too that I don't talk about, but I appreciate you, brother, and I hope your birthday was awesome too. Queen Bee, thanks for 14 months. It's like when we go to Florida. I'd love to go by and to meet him and George, and I understand. I think it's too dangerous. Some members like us, yes, indeed. That is absolutely horrible in that. You know, also, Jeremy said something. He was talking about friends and you know, closing that friend group down too. It's not just the people like members like yourself. It's also, can't trust people as far like look at a lot of these people that were so-called friends, people he helped build channels for. He helped teach them how to do what he does. And you see these people. Now, do you have falling outs? Yes, you can have them. I've had falling outs with people too. And, you know, sometimes falling outs, they can be over, but that should be a limited thing. You shouldn't have groups of these assholes that are out there. Again, he helped build the FATS platform. They might want to argue that, but he helped them get to the point where they could monetize, and they turn around and they fucked him for it. He helped some of these people again learn how to go out to make money, and they fucked him for it. So he's shut down that. You know what's amazing is they're really open about how their business model works too. Like some people treat that like some closely guarded secret. But like one time I asked them about how they did one thing. I'm not going to note it out. And they just walked through the whole process. Like, hey, if you wanted to do something like blah, 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 you can just do A and then B and then C. And it was, I mean, it's so cut and dry. It was amazing. And they've taught people how to do that. And people, they've turned on them and fucked them for it. So, like when you look at some of these people and you listen to their petty bullshit, it kills me. It absolutely kills me there. You know, Pickled Tink, thanks for the 2. Does Jeremy have any other recourse for the protective order? Well, you mean as far as enforcement is concerned? The Ohio courts may decide on enforcement. Now, it would be good if they would go with jail, but you know they exhaust a lot of items before they go to a certain point. And you've seen what 2 violations have gotten. They've gotten warnings, which again, this is not a shot at Ohio when I'm saying this. This is really a shot at that system. They fine them. It's a small fine plus court costs, which is high. But it's that and a don't do it again. Now, with the third one, will they look at jail time? Maybe. They can. But as far as enforcement, I mean, unfortunately, these people are telling him they will not do anything. Now, what they'll do, I bet you money of what they do now, is they pretend to investigate. They will tell him probably that they're going to investigate. And they put their laziest effort forward where they are like, yep, we looked at it, nothing, no problem. But they pretend to investigate. They make a mockery of it. So, you know, with them, I think that, by the way, is an admission of wrongdoing too. If they feel like they need to change and course correct and pretend that they're investigating, I think that's a problem. But not really. Not really. It's pretty nasty. Cruise ship mama, thanks for that. I'm thinking the guy who was taking pictures and looking through the fence might just be the person who's going to auction the property. We don't know who they are at all. It could be anybody. Like, it could be anything. I'm not going to jump to a conclusion, pro or con. For all I know, that could be anybody. It could be somebody that is attached to a court hearing. That could be a person that decided that they wanted to look. It could be an anti, for all I know. Jeez. It could be somebody that said in the past that they wanted to, remember when these people were talking about wanting to take parts of the fence back? It could be one of them deciding, hey, I want to take my fence back. I don't know what it is. Now, they, of course, jump to the conclusion that somehow it's people harassing because Hale. But they have no proof of that whatsoever. And beyond that, going in and exclaiming that, man, one of the kids, that's so gross. I have a garbage can right beside my desk. And one of the kids threw a freaking orange in here. I was like, what is that? You know, like I never use it. It's almost decorative. And I noticed, I was like, what in the world is that? There's a freaking orange over here. Ugh, gross. Sorry, I just got distracted there. I'm curious. We'll talk about that tomorrow, you know, as far as that is. And yeah, we have no idea who or what that is. But they do have, like I said, they have the blood. Well, we'll talk about it again. I don't want to really get off on that, and we'll discuss that tomorrow. Probably as a lead thing, you know. Get me one second there. Oh, yeah, I'm gonna have to restrict. Yeah, I like that. So, one of you noted, by the way, that I'm gonna have to put a restriction on there. So that's funny. So, one of you wonderful antis, by the way, decided the way that they would treat where they can go get files too. Guess what they did? They decided they would try to delete the files out of there because they're douchebags. So I'm going to have to set restricted things, even when they can go in and they can pick up the files too, you know, because I did not set just a download only. I just set a Dropbox on it. What pieces of shit. I tell you, man, what absolute pieces of shit. So that's the kind of garbage people that you deal with, you know. Give me 1 second. So I'm going to, who is it? Let's see. I'm going to see if this I'm going to have to delete the editing portion. And it should, if this causes a problem for anybody who has seen it, I'm going to post the link there. I'm going to do it one more time. I'm going to post it on here for a minute because it may mess with it. But yeah, where you were talking about you couldn't see them, that's the reason it happened. Because some asshole, one of those anti-douchebags decided they would be like, you know what I'm going to do? I'm going to delete it. It's like, well, you came begging for it, didn't you, you piece of shit? God, these people are such pieces of shit. I swear. They're some of the worst human beings that you can ever find. You know, they don't have to be, they're like, maybe I can stop this if I delete it. Oh my God. They're so dumb. So I am reposting a link over on Facebook again. So I'm going to change the link. If it kicked you for some reason, that's why. because I'm having to restrict editing. Such assholes, man. Absolute pieces of shit. How did I know? Well, because one of them decided to write and be like, hey, piece of shit, man. I swear. But, you know, of course they come begging for them. Please give me these, please, sir. You know. Yeah, I swear. They're such sore losers. Okay, let's see. There was one other thing there. And thank you to the person that also, I see somebody also wrote and note certain things too. Thank you. Oh, and hey, James, thank you for writing too. Appreciate you. It said, I love your show and how passionate you are about the law. For some reason, can't super chat you. Well, thank you for going on. Yeah, YouTube says it's on your end. That's weird. Yeah, there's not I don't have any control over super chats. That's a weird thing. Like it's opened, so they're just for some reason. Well, thank you for taking this way. I'll read them there too. Hope we can sort it out. Love your stick. Thank you. Raccoon City. That's right, baby. I love me some Raccoon City. But thank you. I appreciate it. That's everybody here, I think. Let me make sure nothing else came through. But yeah, these folks, again, they want to do stupid things, and they want to try to restrict people. I didn't do anything there, but what nasty weirdos. All right. But anyway, I'm going to jump off here. Appreciate you folks, and we will see you. Thanks. I'll see you tomorrow. Remember, early.